Started. Thank you, everyone, for coming today. As you probably know, my name is Kevin Ruser. I've met.
Can I move these down a little? It's
Yeah.
really
Yeah.
bad.
Go ahead. I know some of you. I know that. Well, many of you practice immigration law. How many immigration practitioners do we have? Okay, so that's intimidating to me. And as I told these two guys right here, I'm going to be looking to you for real answers on immigration questions as opposed to other questions. What other kinds of practitioners do we have in here? Like criminal defense practitioners, anybody? I know we got some. What other kinds of people? Miscellaneous? Okay.
Probate court, misconduct probate court for the guardianships for SIJ.
Okay, so you do SIJ. Okay, good. I mean, I want to talk to you during the break. We're doing a guardianship hearing Monday morning up here, and I'm from Lincoln, and this is kind of like a foreign world to me up here, so get some tips from you.
Sure.
Well, so this presentation is kind of basic in terms of immigration law, and I apologize ahead of time for that. I'll try to, I probably have way more slides than we're going to be able to get through. So I'll try to be selective in what we go through because I don't want to go over stuff that a lot of you know. On the other hand, I do feel like I need to sort of keep it at a level that people who aren't immigration practitioners can follow also. So if you start getting bored or if it's getting too elementary, roll your eyes or something and let me know, and we'll go from there. I'll just have to do this.
The clicker's turned back on.
Oh, the clicker's off?
Yeah.
There we go. That'll help. So obviously, sort of what kicks this off is the Padilla case. And I don't know how many of you have actually read the Padilla case. It's not, I know that everybody knows about the Padilla case, but the facts are kind of interesting. And I just wanted to review those facts briefly with everybody because I think there's some discussion about what Padilla means. Obviously, you've seen that play out in the post-conviction setting here in Nebraska for sure. And probably other places, certainly other places. But just the facts that this guy was a 40-year LPR, so he'd been a permanent resident of the United States for 40 years. He was a Vietnam vet. Now, when you started reading this opinion, you knew right away he was going to win, right? Because when Justice Stevens starts out the opinion with those facts, you know that this is going to go well for Mr. Padilla. He had pled guilty to 3 state crimes. He was transporting about a half a ton of marijuana in his tractor trailer. And he got busted, and he got charged with a bunch of drug offenses, obviously, and the most serious of which was a drug trafficking offense. Got him a 5-year prison sentence, followed by 5 years probation. So when he talks to his defense lawyer and says, well, they're offering me this deal, should I take it or not, his defense, and he specifically says, you know, I'm worried about immigration consequences. And his defense lawyer says, you don't have to worry about immigration consequences because you've been in the country for a long time. Well, that wasn't not only wrong advice, it was probably about the wrongest advice that he could have given him. Up it goes to the Supreme Court. I mean, the Kentucky Supreme Court in that case, which is where the case came from, did what almost every other court, state court in the country did, including Nebraska. There was a 2002 case called, I think it was 2002, called State versus Zarate, in which the Nebraska Supreme Court said the same thing that I think everybody except New Mexico said, which is it's a collateral consequence, and the fact that his lawyer gave him bad advice on a collateral consequence doesn't mean anything Sixth Amendment-wise. So it goes up to the Supreme Court, and the Supreme Court certifies cert on these 2 issues. And the reason that I've got investigate and advise highlighted there is because I know, and you all know, at least those of you who have read the opinion, that there's a sliding scale in Padilla about how detailed the advice has to be that criminal defense counsel gives a non-citizen criminal defendant when they're advising them whether to take a deal or not. And what I'm going to contend for today, what I've always contended for, is that it ought to be as specific as it can be. I understand that what Padilla says is that where the consequences aren't clear, really all the Sixth Amendment requires, or at least there's a reading of that all the Sixth Amendment requires is that you advise them that there could be immigration consequences. And when we get into some of the post-conviction cases in Nebraska, which I hope we'll have time to look at this morning, to me that sort of collapses the analysis into the same as whether the court gave the statutory advisement. It's a very general advisement, and I don't know that it gets to your obligations to your client. And I also don't know whether it complies with the ethical requirements that are imposed on criminal defense lawyers. So anyway, the cert issue is whether or not the Sixth Amendment requires defense counsel to investigate and advise a non-citizen defendant whether the offense that he's thinking about pleading guilty to will result in removal. And then the second issue was really sort of the hot-button issue, which was, okay, there was affirmative misadvice given here, and the Supreme Court was called on to decide whether or not, in a case where no advice was given, whether that would be a problem or whether it actually had to be affirmative misadvice. So the court held that you have to inform your client whether a guilty plea will carry a risk of deportation. And that in this case, and again, those of you who practice immigration law know that this was an aggravated felony. It was a drug trafficking offense. In this case, constitutionally competent counsel would have told this guy, you're going to be put in deportation proceedings. And the court characterizes it as almost automatic deportation. And then they sent it back to the Kentucky Supreme Court because that was only the first element of the Strickland prong of the ineffective assistance. Second element is whether or not Mr. Padilla was prejudiced by this wrong advice. But they had no problem holding on the first prong that it was constitutionally ineffective assistance of counsel, or unconstitutional ineffective assistance of counsel. So here's this question about how detailed immigration advice has to be. And there's this discussion, lots of discussion in the field about these sliding scales. So my take, and I think what the best practice is that you have to be pretty specific about what consequences will result from an immigration, in an immigration case from a guilty plea. Because, going back to that issue that the court granted cert on, that's kind of how it's phrased. If you look at the concurrence from Alito and Roberts, that's what they think the majority held. I mean, they sort of carp about that a little bit in their concurrence and say, geez, this kind of goes too far, we think. And I think the prevailing norms of practice require it. If you look in the Padilla opinion, the Supreme Court cites to prevailing norms of practice, which is really why they held that the Sixth Amendment requires that kind of advice. And I think that ethical rules suggest it, especially in light of Padilla. I think if you look at the ethical rules that are involved and you overlay those onto Padilla, I think all of that leads me to the conclusion that it ought to be relatively specific. And the other thing is, if you're investigating a case to the extent of knowing whether or not there might be immigration consequences, then it feels to me like you have an ethical obligation to your client to share that information with them as part of an informed decision by them on whether to take a plea deal or not. So if you've done the investigation anyway and you've satisfied yourself that you think there is some immigration consequence, that suggests to me you've identified a possible immigration consequence or consequences. And having done that, it feels to me like taking half a cut at the ball to say, well, I kind of know what I think the immigration consequences are going to be, but because it's unclear, I'm going to say to the client, well, there's a risk you're going to be deported, which is all the court's going to tell them during the statutory advisement anyway. And so what have you really added? What value have you added to this whole thing? So there's my pitch. Now, whether that's a constitutional dimension or not, I have my doubts, but I certainly think that it's the best practice. So I will contend for that. This is another interesting issue. So the court held that deportation is an integral part of the penalty imposed on non-citizen defendants. So let me talk about this for a little bit, because I think that there's some interesting advocacy possibilities from that language. our Supreme Court in Nebraska has held, and I think a lot of courts that have looked at it have held, that there is no Fifth Amendment right to be advised of immigration consequences, right? That the court has no obligation as part of its Brady and Boykin obligations to advise a non-citizen defendant of potential immigration consequences. And there are practical reasons for that. A sentencing court can't inquire at the time of passing sentence or arraignment or anything like that exactly what kinds of conversations you've had with your lawyer. If you're a criminal defendant, that would be invading a privilege. But nonetheless, they do have an obligation constitutionally to ensure that a plea is knowing, voluntary, intelligent. I don't know whether I'm saying the right words, but, you know, Brady and Boykin stuff. And with this language in here, it seems to me that if there are possible immigration consequences on the line, that the court has an enhanced obligation in the immigration area. Because what Padilla says and what courts considering Padilla have said is that there's something different about immigration. We will not characterize this as a collateral consequence. It doesn't work in the immigration context. It's something more than a collateral context, and we don't even want to think about it in that regard. So it's not a collateral context. It's part of the penalty imposed, and the court says we know it's not part of the criminal penalty, but it really is part of the penalty imposed on a non-citizen defendant. And if so, doesn't the court have an enhanced obligation to inquire of counsel? You know, more than just a statutory advisement. Yeah, you realize if you're not a citizen that maybe there's going to be some immigration consequences here. Doesn't the court have an obligation to say, have you talked with your client about this stuff? And do a little more than just the sort of routine thing. And if the court doesn't do that, is there a Fifth Amendment argument there? I don't know, but I think there are possibilities. I don't think our Supreme Court has ever had its feet held to the fire on this issue. And I think some smart lawyer, some ambitious lawyer is going to do it. Maybe somebody sitting in this room. But I think there are people out there, a couple of people that I can think of in particular, Josh Ware and Ross Pasick, who are going to make somebody think about this at some point. In fact, I'm going to testify for Ross, I think, in a sentencing case up in West Point next week, where he's making a big deal about why a sentence ought to be this rather than this because of immigration consequences, potential immigration consequences. I don't think he's raising this issue, but I think there's a hook out there. And again, when we go through the post-conviction cases from the Nebraska courts, there's some language in one of the cases that I think really reveals that hook. So there's that issue, and I think that's an interesting Fifth Amendment issue. So as to the second issue on which the court granted cert, they said, well, it would be weird to adopt a rule that penalizes only affirmative misadvice because that would create a disincentive to give the advice. In fact, it would create a perverse incentive not to give advice at all, to just keep your mouth shut. So we're not going to adopt a rule like that. And then, you know, of course, the government said, well, oh my God, the floodgates are going to be open on this. And they said, you know, there is this second prong in Strickland on prejudice, and it's not an easy hurdle to clear. So we're not really worried about that. And then I like this language too, because it's sort of this aspirational language that applies not just to defense counsel. I know that defense counsel in particular feels put upon by the Padilla decision, and I think there are a lot of criminal defense lawyers out there who just assume Padilla had never been decided. But the reason I like this language is because it says this is everybody's concern. It's not just criminal defense counsel, although this certainly is a Sixth Amendment case. But it's the court's concern, it's the prosecutor's concern, it's everybody's concern. And that's really, I don't want to steal Ross's thunder, but that's really the argument that Ross is making in this case, which is that, you know, there are ways to satisfy, and this is the other part of the language, there are ways to satisfy the state's punitive interests and also satisfy the defendant's interest in avoiding removal consequences. And I think you know that sort of that theme of that argument comes from this language in Padilla, and I think that's why the court put it in there, is to say, you know, it works to everyone's advantage if these removal consequences are on the table and everybody understands them and we can deal with them. Now, that doesn't mean that if you've got and again, I'm not casting stones here because I don't know if I got any prosecutors in the office, but if you got a hard-headed prosecutor who says, I don't care about removable consequences, well, they don't have to, but this language suggests that they ought to, it seems to me, and I think the pitch should be made by the judge. And I think given the language in Padilla that says that removal consequences are a part of the penalty imposed, even though it's not part of the criminal penalty, I think that's why you get to make that pitch to the judge at sentencing. And I think you ought to make that pitch at sentencing. I don't think it stops just at whether or not to accept this deal. I think it carries through the sentencing phase too. So there's a lot of good stuff in Padilla, I think. And so if you're a criminal defense lawyer, you can't stick your head in the sand anymore. You have to acquire some working knowledge of immigration law. And here are the resources. Now, I, of course, put my immigration guide first, but the problem is that it's dangerous. It's like a hand grenade from World War II. You just don't know when it's going to blow up because I haven't revised it since 2012. And so you guys all know what's happened since 2012. There have been these cases called Moncrief and DeCamp and Malooly that have been decided since then. So all this analysis I did on statutes that are probably divisible statutes or may not be divisible statutes but fall under the categorical analysis now, it needs to be revisited. So use my guide with some caution. And lay down those cases beside it when you're looking at my analysis in the back of that guide on the individual statutes now, because I did a very conservative analysis when I went through those statutes, and I assumed that sort of the worst case scenario, under the worst case scenario interpreting this statute, here's what I think the removal consequences could be. But I think some of those statutes were in fact non-divisible statutes, and I think that they probably now may not be removable offenses under the Moncrief and the DeCamp analysis. So I still think it's an okay book, but it needs to be updated. So use it with caution, that's all I'll say. Mary Kramer has recently written a new version of her book. I don't know if you're familiar with Mary's book, but it's an AILA publication, American Immigration Lawyers Association publication. And it's been updated since DeCamp and Moncrief, and it's a really good book. If you don't have that book and you practice in this area, I would probably think about getting my hands on it. It's a little pricey if you're not an AILA member. I mean, it's a little pricey even if you are an AILA member, but it's a really good book. Kara Hartzler, who works with the Florence Project down in Arizona and does a lot of litigation in this area, has a really good book called Dealing with Padilla or something like that. And that's the website for her book. And then, of course, you've got these great organizations out there that maintain websites, and they're much better than I am at updating their stuff. So you got the Immigrant Defense Project, Immigrant Legal Resource Center, National Immigration Project of the National Lawyers Guild, Defending Immigrants Partnership, DIP is another one that I don't have up there. They've all got websites. They all put up practice advisories. The Malooly case that came out just a week or so ago, they've all got a bunch of practice advisories on it already, and they're really, really good. So there's a lot of good resources out there. Many of the websites are free. I mean, some of you have to be members of the organizations in order to get into the sort of members-only section. But a lot of them, they're just putting this stuff up for free. So my point is that there's really no reason to say I don't know what I'm doing in this area, because there are lots of resources out there to help you think about it and understand it. So I want to look at sort of, because we got an hour's ethics credit here, I feel ethically obligated to talk about ethics for a while. I want to look at some of the prevailing professional norms and then some of the ethical rules that I think are implicated in this area. So the Supreme Court cites a couple of prevailing professional norms, and they say, you know, this really shouldn't be news to anybody, because these prevailing professional norms have been out there for at least the last 15 years, and people have known about them. And so we're kind of surprised that people think this might be an obligation of defense counsel. And one of them they talk about is this one. And it says, to the extent possible, you're supposed to determine and advise the defendant as to the possible collateral consequences. Now this says collateral consequences. Everybody thought these things were collateral consequences before Padilla, except the New Mexico Supreme Court. I think they stood alone. They were the only ones who didn't think they were collateral consequence. But the point is that even collateral consequences, you know, the best practices, the professional norm would be that you're supposed to advise your client. At one point, Jim Mowbray's office, Commission on Public Advocacy, was putting together a chart of all possible collateral consequences. Do you know if they've done that, Allie? Because that was they were trying to put together a chart of all, you know, you can't own a gun. Yeah, I mean, criminal defense lawyers know all this stuff if you're convicted of certain offenses, and they were trying to put together a chart to make it available to the criminal defense bar. And it's because of this professional norm. I mean, they read this and they say, we think that we have, our best practice would be to try to, even though we're not constitutionally obligated to try to advise people of collateral consequences that might result, because it's part of, you know, informing them fully so they can make a good decision whether to accept a plea deal or not. So that's sort of the wellspring of part of the Padilla's decision. Another one that they mention in Padilla is this one. In order to develop an overall negotiation plan, counsel should be fully aware of and make sure the client is fully aware of other consequences of conviction, such as deportation. Those things, the Supreme Court pointed out, were out there at least 15 years before we decided Padilla in 2010. And I've got fully highlighted again because back to that sliding scale language in Padilla, if you know what the consequences are, then you need to fully inform them, which I think I would contend means more than just telling them you might get deported. I mean, you know, yes, that's probably good enough, but I think you ought to probably go beyond that. So what about ethical considerations? I just want to look at some of the Nebraska provisions here. So you've got the preamble in the Rules of Professional Responsibility. As an advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. Okay, that sounds to me like advising criminal defense clients of potential immigration consequences. As a negotiator, which is what you're doing when you try to strike a plea deal, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. So these are, you know, in the preamble, but again, they are aspirational sorts of things that we're supposed to be doing as part of our role as an attorney, advisor, and negotiator. Of course, the big one is competence. The most fundamental legal skill consists of determining what kind of legal problems the situation may involve. That strikes me as Padilla on all fours. What kind of legal problems are involved? Well, certainly criminal problems are involved, but there are also immigration problems involved, and there may be other kinds of problems that are involved. And so if you're going to practice competently, then that general rule says, you know, thou shalt be competent, basically, but the comment 2 says that involves, among other things, determining all the kinds of legal problems that may be implicated by your client's case. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. That's the rule. We all understand that rule. Comment 5 says, client should have sufficient information to participate intelligently in decisions concerning the objectives of representation and the means by which they are to be pursued. And again, when you think about negotiating a plea deal, it seems to me that the client needs to have as much information as they can, and that we have an ethical obligation to provide that information to them. And I think that means in the case of representing a non-citizen defendant, you need to understand, be aware of, and inform your client of the possible immigration consequences. Because as most of you or all of you know who have done this work, oftentimes, and Padilla said this, by the way, oftentimes the removal consequences are far more important to them than the criminal consequences. And that being so, it seems to me that this rule of professional responsibility is directly implicated. By the way, while I'm thinking about it, has anybody read the decision of the Kentucky Supreme Court on remand? Oh, not the Kentucky Supreme Court, the Kentucky Court of Appeals on remand of Padilla? You know how that turned out? He won. He was able to demonstrate prejudice. And if you haven't read that case and you're doing post-conviction work, you really ought to read it. There's some really wonderful language in there about demonstrating prejudice in the context of this argument, in context of immigration consequences. But what the Kentucky Supreme Court says is kind of what the U.S. Sorry, I keep saying Supreme Court. It went back to their Court of Appeals, which is their intermediate court. So it goes back to the trial court, right? The Supreme Court sends Padilla back to the trial court because we have to get evidence on the prejudice prong of Strickland. And he loses at the trial court level, not surprising, right? And then it goes up to the Court of Appeals. So their structure in Kentucky is just like ours in Nebraska. Trial court, Court of Appeals, Supreme Court. Goes from the trial court to the Court of Appeals. The Court of Appeals reverses and says, we think he demonstrated prejudice. And the reason is, and there's a lot more facts that come out that are really interesting about how this guy got busted and why it happened that they found the marijuana. And it's really interesting. And so you ought to read it just because you need to know the ending of the story. But the Kentucky Court of Appeals says, there really is something different about immigration. There's this sort of different standard we're going to apply when we're determining whether or not prejudice has been demonstrated under Strickland's second prong. Because it's immigration, we can't think of it as we do sort of a garden variety criminal case. And again, I think there's some really good language in there if you're doing post-conviction work that you ought to take a look at. But it's a good decision. And the state did not appeal it, did not even ask for further review by the Kentucky Supreme Court. So it's a final decision. Anyway, I just happened to think of that. So take a look at that case. It's a good case. Got good language in it. I don't know if you all remember this case, this Orr case. This isn't exactly on point, but I think it drives home the point. So in this case, this lawyer in Nebraska represented somebody who wanted to, I think they wanted to be a franchisor anyway. And he was a general practitioner, and he didn't know what he was doing, and he screwed the case up, and the client suffered some severe harm, and this guy got censured by the Supreme Court, got publicly reprimanded. And there's this language from this case, and we take this opportunity to caution general practitioners against taking on cases in an area of law with which they have no experience. And then down at the bottom, if a general practitioner plunges into a field in which he or she is not competent, and as a consequence makes mistakes that demonstrate incompetence, the code demands that discipline be imposed, okay? So this is more than just an aspirational goal. You can actually suffer some harm. It seems to me that there are parallels between this decision, although it's not involved in the criminal area, it's not involved in the immigration area, but it's involved in an area of where if you are a general practitioner, even if you're a criminal law practitioner, and you're representing clients, you need to know whether or not they're citizens of the United States. And if they're not citizens of the United States, you need to know what the possible immigration consequences are that they're facing. And if not, it seems to me that it's akin to this situation where this guy took on a case that he didn't know what he was doing in. So you've either got to educate yourself, or, as this case says, you have to associate yourself with someone who knows what they're doing in this area. Because if you don't, it's not just a Sixth Amendment violation. It's not just a Strickland claim. It's not just a post-conviction case. It's also a possible disciplinary case, too. I think this was egregious on the facts. I don't think that most of the cases under Padilla would be as factually egregious, at least in the eyes of the Supreme Court, but it's out there. And again, as lawyers, we want to try to do our best. I mean, that's what we want to try to do. So be aware that the Supreme Court will impose discipline in the right cases. And there have been cases in this state, as we all know, where discipline has been imposed on immigration practitioners. So it can happen. Okay. when I think about what I want to tell clients as to possible immigration consequences, I want to know this sort of stuff. I want to know, obviously, what their immigration status is. Not just whether they're a citizen or not, although that's not a bad start. I mean, certainly that's got to be part of the investigation. But I want to know, if they're not a citizen, what kind of non-citizen they are. Because as we all know, there are different kinds of immigration consequences depending on what kind of non-citizen you have. If you have what I'll call a garden variety non-citizen, their immigration consequences might be different than someone who has temporary protected status, who can lose that status upon the conviction of a second misdemeanor, or somebody who's got DACA, Deferred Action for Childhood Arrivals. So there are different immigration consequences depending on the flavor of non-citizen that you have. So you need to know what the immigration status of your client is. That's got to be part of the investigation. And then once you get into that, once you get past that hurdle, then I think you want to just sort of run down that list. Are there inadmissibility consequences? Are there deportability consequences? Is this an aggravated felony that they're facing? Is there going to be mandatory detention as a result, which I think is a huge issue for most of the clients, maybe the biggest issue for most of the clients. Whether the plea that they're thinking about will imperil any potential relief from removal. There's been argument made, I've heard argument made, that really the only thing we have to worry about here is whether or not it's going to result in their removal from the country. But I think the first Gonzalez case that our Supreme Court decided, and we'll look at that case, really pretty clearly holds that even if it is some sort of affirmative relief from removal that might be screwed up by this plea deal, that could state a post-conviction claim. So I think that those are the kinds of things you want to run through in your analysis. And then I think you also want to think about what I'm calling inchoate immigration consequences. They're not really direct consequences, but they're things that that may come into play, like, are there any good moral character bar problems here if this person takes this deal and gets convicted of this crime? And is this a particularly what's called a particularly serious crime that relate to other kinds of immigration benefits that they might want to pursue? I think you want to think about that stuff as well. So now just some miscellaneous questions that occur to me as I sit around and think about this stuff. So we know that criminal defense lawyers have a Sixth Amendment obligation to advise on possible immigration consequences. And we also know that there's a statute out there that's existed since July 20th of 2002 that says that the court has to read this advisement to anyone anytime they are accepting a guilty plea from them. And the question, I guess, that's posed is, well, suppose the court gives this advisement, but the criminal defense lawyer doesn't counsel the client on the Sixth Amendment implications. Does that advisement cure any failure of counsel to advise? And I was telling these two guys, I lose cases right and left, and one of my losses in the Supreme Court, the implication is no, or yes, that it does cure failure of counsel to advise. In that case, and I'm going to take a moment of personal privilege here to carp about this case a little bit, because I still think we should have won it. So there you go. I have a captive audience. You can't go anywhere if you want your credits. You're stuck listening to me carp for a minute. But in that case, we had a guy who pled guilty to attempted first-degree sexual assault and got this much advice from his criminal defense lawyer, private lawyer. I'm not going to mention any names. This much advice on it. He took the deal, and he's incarcerated. He's sentenced to time served plus about 20 days. So he's in state custody for 20 days. ICE comes and gets him on the day that he is released from state custody. He says, "What are you doing here?" And they said, "Well, you are our guests now. We're taking you into our custody because," I have a slow connection, I know that. because you've been convicted of an aggravated felony. And he goes, what's that? I never heard about that before. Anyway, he gets an immigration lawyer. He tries to fight it. He loses. He gets an order of removal entered. His lawyer contacts us, his immigration lawyer, and says, is there anything you can do for this guy? Well, on the heels of Josh Ware's really good litigation establishing this common law right to vacate a plea, we file a post-conviction claim for him up here in Douglas County and lose because they say you could have gone under the Nebraska Post-Conviction Act because at the time that his claim arose, he was in state custody. Now, he didn't know what the immigration consequences were, but he was in state custody for 23 days. And I said to the student, that can't be the law. That cannot be the law. How could he know that he was supposed to do anything during those 23 days? So, being stupid, I say, let's appeal this decision. And we go up and the Supreme Court said, yeah, that's the law. And one of the things they say in that case is, he was told by the judge, because the judge read him the advisement. We had no argument under 29-18-1902. He was told by the judge at the time that he entered his plea, he was read this advisement, and that would have put a reasonable person on notice. And yes, he was pro se in terms of the immigration part of it, but they're held to the same standard as someone who would have been represented. And so, in fact, the Post-Conviction Act was available to him because one of the requirements of having that common law vacature procedure available to you is that the act never was and never could have been available to you. It was available to him as a matter of fact. He should have proceeded under the Post-Conviction Act during those 23 days he was in state custody. He didn't. And this advisement that he got from the court should have put him on notice that there was something amiss, and he ignored it at his peril, so he can't proceed under the common law motion to vacate. That's a harsh result. I know the court hates post-conviction claims, but this is latest evidence of how much they hate those post-conviction claims like this. But they make a lot of hay. McCormick writes the opinion, a lot of hay out of the fact that he got this advisement. And so I've kind of overstated the question here, but basically that put him on notice, and the fact that he got no advice from his criminal defense lawyer under his Padilla obligations didn't matter. Okay? So now I'm done carping about my bad decision. State versus Mammer. Yeah, September 2014.
Did you say you had a criminal defense attorney? You said something about being pro se.
Well, so the Supreme Court characterized, he had a criminal defense attorney, yes, but the Supreme Court said he was pro se in terms of the post-conviction claim. They characterized it as being pro se in terms of the post-conviction claim. So he had a defense attorney up through the guilty plea. He pled. He's in state custody for 20-some days, and that's the point in time that he should have known that he had a post-conviction claim. And so I'm going to carp a little more because I can't stand not to. So what the Supreme Court says is that Mr. Mammer fundamentally misunderstands what he knew and what he didn't know. It's not, and our argument was that this is sort of like knowing when you have a cause of action for statute of limitation purposes to file a civil case. All you have to know about are the facts. You don't have to understand that they're actionable. And he knew that he wasn't advised of the immigration consequences by his criminal defense lawyer. And the fact that he didn't know that there were immigration consequences until I showed up the day he was released from state custody doesn't matter. Yeah, well, Padilla fails entirely. How did it fail?
How was the analysis on that?
The analysis was he could have vindicated his Padilla claim under the State Post-Conviction Act.
But you don't need that for a Padilla claim, right?
Well, our Supreme Court said there's no way for him to vacate this plea. Yeah.
Was he maybe put on notice based on the filing of a detainer?
There was no detainer.
No detainer was
no
filed.
detainer.
That was the point in your paper too, then.
Yeah, I know. I thought it was a great set of facts. I really did. Yes?
Can I have you repeat the audience question?
Yes. Okay, so the first question was, how did Padilla fail? And Padilla didn't fail in the sense that he didn't, I mean, he had the claim. It's just that there was no remedy for him to effectuate that claim, because there's only 3 ways once you've entered a plea that you can vacate it, right? You can vacate it as a result of the State Post-Conviction Act. You can vacate it if you didn't get this advice under 29/18/1902, and you can vacate it under this common law motion now, but only if the other 2 claims were never available to you. And so we couldn't go under the statute, and we didn't think, oh, well, we couldn't, because by the time the case came to us, he was already out of state custody, so we couldn't go under the Post-Conviction Act at that point. So the only thing left to vacate that plea was the common law remedy, and they said, too late.
Did you file a motion to withdraw the plea, or did you try to do a quorum novus?
Quorum novus doesn't work.
So
Well, we filed a common law motion because that was the only thing that we could do. And they said that's not available. And the second question was, I'm sorry.
Detainer.
Oh, detainer. Was there a detainer? Was he made aware of ICE's interest in him as a result of an ICE detainer? And the answer is no, there was never an ICE detainer. They just showed up on the day. I mean, they knew about him, obviously, but there was no detainer ever filed. Those were the facts in that case. So that's hard, right? That's a hard case. Okay. All right. I'm done. No, I'm not. Good. Chris is going to let me gripe some more. Go ahead.
So I guess what was their analysis just that he could have filed under the State Post-Conviction Act, didn't, and that's why now the manifest injustice
Can't be demonstrated. Manifest injustice is available, but he can't. There's no remedy to, there would have been manifest injustice, I'm sure, because the first prong of Strickland said this much advice on immigration consequences is, constitutionally deficient lawyering. So there was manifest injustice. It's just that he had no remedy to allow him to vacate that plea at that point in time. That's the problem. So it was on the remedial end of things that we got hung up, not on the front end of things. Okay, good. I love being affirmed by this group. This is good. But at least, and we argued this Third Circuit case, because this Third Circuit case in this Orosio case in 2011 says, that's not, that sort of generic court advisement that the court gives, and this is under Rule 11, I think, in federal court, it's too perfunctory, it's too general, it happens at a busy time, people say, yeah, they don't really know what's going on, they don't process it. And so we don't think that even if the court gives that advisement that it cures a Padilla deficiency. But the 7th and the 10th Circuit, and by the way, the 7th Circuit, yes, that is the same Chaidez case that held that Padilla is not retroactive, that went up to the Supreme Court. In those 2 cases, they kind of side with our court in Namur. They kind of say, yeah, that puts somebody on notice. And so the fact that there is a Padilla screw up here by counsel doesn't really give rise to a remedy, because they should have heard the court, which is why, to sort of come full circle on this sermon that I'm preaching to you guys on the sentencing end of thing and the Fifth Amendment argument, why it's important to hold the court's feet to the fire, I think, and if I get a chance to talk to judges again, I'll tell them this too, that you really ought to just go beyond the perfunctory advisement under the statute. You really ought to say, have you really talked with your lawyer about this? Now, I know it's busy, particularly in county court. They run these things through, and I understand that. But, again, if lawyers have an obligation, I think courts have an obligation too. And I think, if for no other reason than cutting down on possible post-conviction claims, they ought to really satisfy themselves as a judge that there's been some substantive discussion between defense counsel and their client about this. And I guarantee you that if the court had inquired in Mr. Mammer's case, he'd have said nothing. Because I not only believe him, but we were able to substantiate there was no advice at all given. And he pled guilty to first-degree assault, basically attempted first-degree assault, but for immigration purposes, first-degree assault. I mean, that was the original aggravated felony, right? Rape and murder. So anyway, okay, all right, I'm done on that. So these are some basic immigration concepts. I don't know whether I need to go through all of these because most of you folks here understand what these are. I'll maybe breeze through some of them. And again, this is how I think about analyzing a case. I mean, I like to think in outlines, and so when I do my analysis in the end of my guide, I go through and I analyze these criminal statutes. This is kind of the analysis I do. Are there inadmissibility implications if inadmissibility is an issue in your client's case? Are there deportability implications if your client is deportable, if that's the issue? Is it an aggravated felony? Because that's a huge issue. And then we get into the sort of what I call inchoate inquiries, right? Are there any good moral character implications? Is it a particularly serious crime? And are there any mandatory detention implications? And I'd probably move that last one up the ladder in terms of hierarchy. I might even put that first because, again, that's a huge issue for most clients. But there may be other immigration consequences that you want to think about. For example, I could probably add number 7 there, which is if you've got a status now, are you going to lose it if you take this deal? I'm thinking of TPS, I'm thinking of DACA, I'm thinking of those kinds of things. But generally speaking, those are the kinds of questions that I run through at the end of my guide when I go through the criminal statutes and analyze them for immigration consequences. So I think most of you that practice immigration law, all of you that practice immigration law, understand that in 1996 we got a new, well, 1997, it was effective April 1st of 97, we got a new definition of admission into the U.S. Before it read a little different, but as of April 1st, 97, here's when inadmissibility is the issue, right? The client is or may be in the future actually seeking admission to the U.S. Or from within the U.S. under adjustment of status, or the client's physically present in the U.S. without having lawfully entered, so-called EWIs. Inadmissibility is the issue for them rather than deportability, even though they're physically present in the U.S. If they're caught and placed in removal proceedings, if they want to stay, they've got to prove they're admissible to the U.S. Or the client is a permanent resident, but one of those 6 provisions applies to them. So even if the client has a green card, they may have to worry about inadmissibility issues if one of those 6 things applies to them. And all of these considerations come from Section 101A13 of the Immigration and Nationality Act. So if inadmissibility is the issue in your client's case, you need to be familiar with that provision of the statute. The statutory grounds of inadmissibility as the result of criminal acts are mostly found at 8 U.S.C. 1182A2 and A3. There are some other ones that are kind of criminal related, I suppose, in some ways, but most of the criminal grounds of inadmissibility are going to be found at that section of the code. And the common grounds, criminal grounds of inadmissibility are these. Sort of the common with crimes involving moral turpitude, et cetera, et cetera. Probably nothing surprising on that list. There's a health-related ground of inadmissibility which is quasi-criminal, and so I always like to mention that. And again, I know all of those of you who do immigration practice are familiar with this, but it's implicated in drunk driving cases. But someone is inadmissible to the United States if they have what the Act calls a physical or mental disorder posing a threat to property, safety, and welfare of the client or for others. And Immigration and the Department of State look at this very closely in drunk driving cases. So although drunk driving cases in and of themselves aren't going to make your client removable from the United States, if they need to worry about being admissible to the United States, then drunk driving cases are going to matter to them and should matter to them. And you'll probably want to talk with them about whether or not it's a good idea to plead to a drunk driving case. I mean, maybe they have no choice, but you at least ought to talk. Yes?
Maybe I should have addressed this question when you were talking about advice, but in Douglas County what they're doing is they're still laying low in the probation office. You plead to a DUI, they have a conviction, you're merrily on your road to completing your probation, you show up at your probation meeting, and you're detained and put in removal proceedings. And if you've had a couple DUIs, the bond is set pretty high, and they start pressuring you. Is that part of what you would consider to be ethically necessary advice to give somebody? Because what you're saying is maybe don't show up for court.
Yes.
Right?
Well,
I mean, where are you at there?
Yeah, you have various ethical obligations. So the question is, you've got this situation in Douglas County, and I thought the ACLU had hammered that out to a certain extent, by the way, but still going on.
They're picking them up. They just make sure that they have a warrant.
Okay.
They're still going to ground.
So they're not just snag fishing. They're actually casting bait now.
Sure.
Okay. So the question is, so you've got this situation in Douglas County where somebody pleads to a drunk driving offense or more than one, maybe a subsequent one. They're put on probation, and then ICE is notified, and they show up at the probation office, take them into custody. And if they don't have a driver, and so they show up and take them into custody, and then the bond is set very high. And the question is, how do you advise somebody that that's a possible immigration consequence without violating another ethical provision about advising them not to follow a court order, right, and not show up? So here's how I've always sort of sliced that bread in my own mind, and you guys can tell me whether I'm thinking about this right or not. And it seems to come up a lot in the immigration context. I have potential asylum clients that will come to me and say, here's my story, and I'll say, well, I don't think that's a good asylum claim, and they'll say, why? And then in my early days, I would tell them, and then I think they walked down to the street to another immigration lawyer, and all of a sudden the story got a little better because I had just coached them about where the weaknesses in their stories were. So the way that I handle, and also if you've got people that are, in the country without documents, what do you tell them about staying in the country? What I've always done is I'd say, in this case, I would say something like, so here's what's going to happen. What's going to happen is this, and this. And likely, based on my experience, what's going to happen is ICE is going to be waiting for you when you go in there that last time. And then I stop. And I don't say anything else. But I will answer questions. If questions come up, I will say, if the question is, okay, so should I go or not? I would say, I can't advise you not to go. But what I can tell you is that ICE is going to be there waiting for you. That's kind of how I've always resolved that ethical dilemma. I mean, how does that feel to you? Does that feel like that would be an okay way? That's what you do. Yay. So I've got one other person in my camp. Any other ideas on how to handle that situation? Because that's about the best I can do. I don't think you can say don't follow the court order, but I do think you have an obligation to fully inform them of what's going to happen as they're complying with the court order, and I've always thought that I could answer questions posed by the client. That doesn't involve affirmatively telling them to disobey a court order, but it upholds my ethical obligation to fully inform them of the consequences of what's going to happen here. And again, I mean, to back that up to the Padilla level, I think you probably want to do that, at the time you're advising them whether or not to accept that plea. You're going to want to play it out down the road for them, which is why it carries through the sentencing phase and even the probation phase, I think. I think that's part of what you got to do.
Then you're preparing them for eventually having to save money to post a high bond.
That's exactly right. That's exactly right. You're telling them you start saving your pennies because you're going to need them. That's exactly right. Yep. Okay. This is probably obvious, but a lot of times I'll get a question from criminal defense lawyers, well, my client's an EWI, he's here without documents, he entered without inspection. If they find him, they're going to remove him anyway. Why do I worry about them? And my response is you worry about them because you don't know, probably as a criminal defense lawyer, non-immigration practitioner, whether or not they might be able to get status someday. It may be that they can sometime in the future, and you want to preserve that right for them. So yes, the fact that they are here without documents in and of itself makes them removable, but you still want to worry about that issue because maybe they're going to be able to adjust status, maybe they're going to be eligible for cancellation of removal if they're a non-permanent resident, and you want to preserve those benefits or the possibility of those benefits for them. Okay, so that's inadmissibility. Again, I apologize, this is basic for immigration lawyers, but so the grounds of deportability is that your client is here lawfully, but now he or she has done something to make them removable from the United States, and the government wants to kick them out. And the statutory grounds, most statutory grounds of deportability are found in 8 U.S.C. 1227A2 and A4. And there's the list. And there's a possible list. The ones with an asterisk by it are grounds of deportability that don't have a comparable ground of inadmissibility, although there's overlap. So when, and again, many of you know this, if you've got someone who's convicted of an aggravated felony is a category of deportability, but it's not a category of inadmissibility. However, many aggravated felonies are also going to be other kinds of crimes that will make you inadmissible as well. Firearms offenses, that's a ground of deportability only. Domestic violence offenses, and again, it's not that the crime couldn't be thought of in different ways, but it's just as a category, those only exist on the deportability side and not on the inadmissibility side. Okay, so convictions, some clients can be removed from the United States if they've been involved in criminal activity, even if they haven't been convicted of a criminal offense. If they're a drug abuser or addict, they're inadmissible, whether or not they've been convicted of a criminal offense. If they admit to committing a crime involving moral turpitude or controlled substance offense, they could be inadmissible, although that admission has to take place in a fairly structured setting. It can't just be telling your cellmate about it. But, you know, it's possible to have someone inadmissible if they admit to that, whether or not they've been convicted of it. And then if they're a controlled substance trafficker, they could be deemed to be inadmissible whether or not they've been convicted of an offense. But other than pretty limited exceptions, you have to be convicted of a crime in order to be removed as a result of that crime. And a conviction, okay, yeah, so forget about that. So a conviction is statutorily defined in 8 U.S.C. 1101A48. And it's got prongs, and I've got the language highlighted there. A formal judgment of guilt entered by a court, or a judge or a jury has found the client guilty, or the client has entered a plea of guilty or nullo and has admitted facts sufficient to warrant a finding of guilt, and the judge has ordered some form of punishment, penalty, or restraint to the alien's liberty. So you have to have A or I and double I in order for there to be a conviction. And the Board of Immigration Appeals, as to that double I prong, has held that it takes very little. Imposition of court costs is enough, the Board of Immigration Appeals has held, to satisfy that last prong. So it doesn't take much after you've got an admission of guilt or a finding of guilt in terms of some form of punishment, penalty, or restraint on their liberty. Imposition of costs is a punishment, the BIA has held, and that's enough, or a penalty. So how do you avoid a conviction? Well, at the pretrial stage, you have pretrial diversion, which certainly works because there's never a plea entered, right? Does Douglas County have pretrial diversion? Yeah. Lancaster County does. There are some counties outstate that do not have pretrial diversion. It's on a county-by-county basis. So if you're in a county with pretrial diversion, then pretrial diversion works really, really well. Post-conviction vacature proceedings sometimes work, unless I'm representing you, in which case you're going to lose. So you've got this Pickering case, which is a real interesting case, and I'm going to see if I can remember the facts of it close enough not to be accused of misrepresenting. But you had this guy who I believe was a Canadian citizen. He had been convicted of a Canadian criminal offense. He wanted to I think be admitted. I think admissibility was the issue, not deportability. And the problem was that he had this Canadian criminal offense that was making him unable to obtain that benefit. So he went back to the Canadian court and said, hey, I'm having some immigration problems in the U.S. I want to get this conviction vacated, or at least that's what the BIA says that he said. in its opinion, and the Canadian court, being a Canadian court, said, "Oh, no problem. We'll vacate it for you. We don't care. We don't really like to imprison people anyway, so we're sorry we did it, and we'll vacate the conviction." So he takes that to the service, and he says, "Look, conviction vacated." Now the service says, "Ah, yes, but you didn't vacate it for the right reason. You vacated it in order to get an immigration benefit, and that's naughty. You shouldn't have done that. So we're not going to, we're going to say that that was sort of an impure motive, and that doesn't count. A conviction done, a vacature done for that purpose isn't effective for us." Now, the vindication for Mr. Pickering is that he went up to the Sixth Circuit. And the Sixth Circuit says, you know, as a general proposition, we're going to, under Chevron deference, we're going to say that it's okay for the BIA to impose this rule, that, you know, it has to be done for a pure purpose, right? And a legal error or a constitutional error rather than I just want to get an immigration benefit. But here's the thing, in Mr. Pickering's case, government, guess whose burden of proof it is to show why, whether it was done for an improper motive? It's your burden of proof. And we're looking through this record, and all this stuff that the BIA thinks they saw, we don't see in the record. We don't see that you carried your burden of proof to show what his motivation was for getting this conviction vacated, so we're going to reverse that decision. So ultimately, Mr. Pickering wins in front of the Sixth Circuit because the government failed to carry its burden of proof. So if you're trying to get a conviction vacated, be careful about why you're asking for it, right? I guess is the lesson of Pickering. Then you've got this Adamiak case that comes down 3 years later through the BIA, and that case is basically a case that's, I think it's out of Pennsylvania, it came out of Pennsylvania, that's just like one that you would have in Nebraska under our 29-18-1902 statute, which is court failed to give a statutorily required advisement at the time the guilty plea was entered. Mr. Adamiak wants to, does avail himself of the statutory vacature provision, gets it vacated for that reason. The government says, yeah, but there's this Pickering case out there. He's doing it clearly to get an immigration benefit. And the BIA said, well, you know, but there was this problem, right? There was this, I'm trying to sum up the words. But anyway, it was done for a legal error. It wasn't done for solely for the purpose of getting an immigration benefit, so it's okay. So they distinguished Pickering from that case. And then, of course, you got Padilla, which is the obvious example of a post-conviction vacature proceeding. So there are those cases out there. You've got this criminal set-aside, right? We're doing some work in our clinic for veterans under this case. Some of you may have used this statute in order to get the civil penalties associated with certain kinds of convictions removed so that people can put on their job applications, I've not been convicted of a criminal offense. If you get the set-aside, the statutory set-aside under that statute, the statute entitles them to say on job applications, I've not been convicted of a crime. It's sort of an expunction kind of provision, but it's not quite that. But the point is that that doesn't work. If you would get that set aside for your client under that statute, it doesn't work because they've been convicted. In this matter of Roldan case from '99 says a state rehabilitative scheme like that one isn't sufficient to have vacated the conviction for immigration purposes. Drug court doesn't work either, right? Because you've got a conviction plus restraint on liberty. As I understand the way drug court works, you have to plead guilty, and then you have to go to drug court. And those are the two halves of the equation. That equals a conviction, and that means that you have been convicted. So again, unless you can get that conviction vacated for reasons of legal infirmity, it's going to stand for immigration purposes. The statutory provision does work, because it's just like the issue in the Adamiak case from the BIA. But there are these post-conviction cases in Nebraska that you need to read, and we'll go through some of those. You actually need to read way more than that. There's been a lot of litigation under that statute, post-conviction-wise, in Nebraska. So those are different options available to avoid immigration consequences or avoid a conviction altogether. Okay, so there may be instances when both inadmissibility and deportability are issues. and I've listed some up there. You've got non-LPRs, right? Like students, they may want to travel and come back, and they're going to be subject to the admissibility analysis when they come back into the United States. You got a permanent resident who leaves and stays away for more than 180 consecutive days. The statute in the act says they are deemed to be seeking admission when they return. And if they leave after they have committed a post-April 1st, 1997 inadmissible offense, if they're an LPR, they leave and they want to come back, they're going to be deemed to be seeking admission under the definition in the statute. Now, there's this, I tell the story about this Collado Munoz case because it's just a classic case of somebody that got trapped by this. The Supreme Court partially remedied that decision in this Vartelis decision in 2012, but I don't know if many of you are familiar with this case, but it's a great story, so bear with me, I'm going to tell it. But Mr. Collado was, I think, a Dominican national. He was convicted in 1974 of misdemeanor sexual assault. He had sex with his underage girlfriend, and her mother turned him in because she was unhappy with him, and he got sentenced to 3 months probation. And that happened in 1974, and he's been going back and forth to the Dominican Republic, you know, almost every year to visit his family. Well, he has the bad fortune to leave the United States in late March of 1997, goes back to the Dominican Republic after April 1st of 97, presents himself at a port of entry, and they say, we're not letting you in. And he says, why not? And they said, well, because you're inadmissible. He says, no, I'm not seeking admission. I'm an LPR. You understand this fluty doctrine, brief, innocent, casual departure. I'm not deemed to be seeking admission. And they said, you are as of April 1st, because IRA became effective April 1st, and we now have this new definition of admission. And you're inadmissible because you committed an inadmissible offense, sexual assault of a minor. We see it right here in your record. He says, yeah, but that was in 1974, and I got 3 months probation, and that's all done. And they said, well, no, you're inadmissible. So they exclude him from the United States. Eventually it gets worked out, but that's what that decision held was, yeah, that's a permissible reading. Now, what the U.S. Supreme Court said in Vartelis in 2012 was it's an admissible reading prospectively, but not retroactively. So any convictions that took place before April 1st of 97 don't count. You can't, it doesn't apply retroactively. But if you got an LPR who commits an inadmissible offense after April 1st of 97, and that LPR leaves the country and they want to come back in, we are going to screen them under the inadmissibility analysis. So if you got an LPR who travels abroad, regardless of how long he or she is staying out of the country, and they're facing an offense, you got to run both the deportability analysis, obviously, because you worry about them getting booted out of the country, but you also probably want to run the inadmissibility analysis on them, because if you know that they go out and come back frequently, they need to understand that they might be deemed to be inadmissible when they come back in or when they present themselves at a port of entry. So, particular serious crimes, I think we're going to skip. Good moral character, I think we'll skip. I'll leave that for the slides. Removal procedures, I'm going to skip unless somebody wants me to go through those. Does anybody, I mean, I see a lot of immigration lawyers here. Does anybody want me to talk about how removal proceedings work or don't work? No. I'm not going to ask the question. Does anybody want me to just stop now? Okay, so we'll skip through that. And we'll skip through the post. Okay, let's talk a little bit about the removal priorities memo that came out in November of last year, because it's a huge player right now. So you've got this removal priorities memo that ICE, Immigration and Customs Enforcement, issued, and it sort of supersedes all the previous enforcement priority memos that were out there. The purpose of this, and this is sort of the thing that's caught up in all the litigation that's going on over the so-called administrative action these days. But The purpose of this is that ICE only has the resources to deport or remove from the U.S. a certain number of people each year. And I was at an AILA conference a couple of years ago, and the then director of ICE said, I have the resources to remove 400,000 people a year from the United States. And I am removing 400,000 people a year from the United States. And those of you who follow the statistics know that that's true. That is what they're removing. In fact, a lot of people have called Obama the deporter-in-chief. He has deported more, his administration has deported more people than any other administration. And some people that would otherwise be his political allies aren't very happy about that, but it is a fact. But he said, this ICE guy said, so I can only deport so many people because that's all I have resources to deport. So I've adopted this priority memo, and we're going to focus our resources. So that's the purpose behind this priority memo, and they've got different priorities, and you can look through the memo to see what they are. But aliens who pose a threat to national security, border security, and public safety. All of those things, anybody who would fall under any of those categories. And if you look down at those bottom two bullets, convicted of a state felony offense or an aggravated felon, those are in priority 1 for removal. So they're high on ICE's priority to remove. If your client is convicted of or pleads to an offense that involves any of these things, they're priority 1 for removal. And I think you need to tell them you're going to be removed. You're going to be placed in removal proceedings. Priority 2 would be misdemeanors and new immigration violators. But if you look at that, those two bullets, convicted of 3 or more misdemeanors arising out of separate incidents other than minor traffic offenses, convicted of any significant misdemeanor, domestic violence, sexual abuse, burglary, firearm offense, etc., they're in priority 2 for removal. And I think you need to tell your clients, because a lot of clients want to know what's the realistic possibility that I'm going to be removed. And the answer is, if you're in their priorities, you're likely to be removed. You're going to be taken into custody. These are other priority 2 people. And then priority 3 people would be other immigration violations. Those have been issued a final order of removal on or after January 1st of 2014. But you need to be familiar with that priority memo, because you need to tell your criminal defense clients, here's the realistic possibility that you're going to get removed. And if you fall on one of those priorities, you're going to get removed. The case that Ross is arguing actually involves an operating without a license. And the policy of the county attorney in the county in which he's litigating this case is that if we've been convicted of 2 or more such infractions, then it's our policy to ask for 3 days of jail time, period, across the board. And what Ross is arguing is that's fine and good for everybody except non-citizens, but it's unduly harsh for non-citizens. And what's the purpose behind the policy? But he's making that argument because he's aware of this stuff. I mean, he's able to make that argument because he's aware of those kinds of issues. So it's good lawyering. Now, whether it will work or not, I don't know, but it's the kind of thing that Padilla, I think, hoped criminal defense lawyers would do. But he's got his eye on this. I mean, he knows, even though they're not in a priority, that if they land in jail, ICE is going to pick up on them and be interested in them and likely come get them. Yeah, I don't know that I need to go through that stuff. And relief from removal also, I mean, all of you know about that, but it's basically what I would call an affirmative defense to removal cases. Various types of relief are available, which is why, going back to the list of how do you know what kind of non-citizen you have here, it's why it's important to determine what kind of non-citizen you have here, because there are different kinds of people. They might be eligible for different kinds of benefits, and all of those benefits have different eligibility requirements, and all of those eligibility requirements will be involved in different kinds of criminal actions. Yeah, that's probably something we can skip over. And then this is kind of my outline for, how do you analyze a criminal case for immigration consequences. And we've kind of already looked at that kind of stuff, so I don't think we'll belabor that. So what I propose to do now, we're about a little after 10:15, is take about a 15-minute break, and then we'll come back and finish this stuff up.
So I've got this guy.
I have a question from one of the people that are webbing in. For some reason, this person in Scottsbluff County didn't want to drive to Omaha today. I don't know what that's all about. But anyway, hello in Scottsbluff County. It says, I'm a deputy public defender in Scottsbluff County, and I've been working on to plead an impossible case in a manner that does not result in removal for our undocumented clients. In cases in which clients are charged with third-degree domestic assault, Class 1 misdemeanor, would it help if they pled down to attempted domestic assault? Or would that be just as bad and result in removal as a crime of violence? So I might need some help from the immigration lawyers in the audience on this one. So these are undocumented clients, right? So we know that the issue is one of inadmissibility, right? So because deportability isn't the issue when you have an undocumented person. So the grounds of deportability under 237 of the Act don't apply. That's where the domestic violence ground, criminal ground, is under Section 237 of the Act. So they're not removable from the United States if they're undocumented because of a domestic violence conviction. So then you flip over to the inadmissibility analysis, and the question is, are they inadmissible if they get convicted of third-degree assault? And the only ground that I could possibly think of that would be implicated would be a crime involving moral turpitude, and I think it's pretty well settled in this jurisdiction that third-degree assault is not a crime involving moral turpitude. I'm looking for some affirmation out here. Does that sound right to you guys? I think that's how our immigration court thinks about it here. So I think that for an undocumented client to plead to third-degree assault, even if it's, well, okay, now I'm going to think about it some more. But if it's got a domestic overlay to it, there is that BIA case called Matter of Tran that seems to suggest that domestic assaults may be crimes involving moral turpitude. That in other words, certain assault cases, generally common misdemeanor assault generally isn't thought of as a crime involving moral turpitude, but depending on the victim, it might sort of be. And they've got the Tran case that says domestic assault. Domestic assault may be a CIMT because of the nature of the victim. Assault on a cop may be a CIMT because of the nature of the victim. So now I'm rethinking that. It would be better if you could, in the plea colloquy, probably eliminate any reference to the nature of the victim. I think if you could do that and just get them to plead to generic third-degree assault, I think you'd be in good shape. Pardon me?
Addition.
Ah, okay. And what about a felony under 101F? 101F. So we're worried about.
Plus, on the Class 1, if he spends more than 180 days, he can't show good moral character, right?
Right. And so I don't know if that's what the 101.
That would make him non-cancellation eligible too. So you better work on your sentence there too.
Yeah. I mean, the good moral character issue is what the 101F is talking to. Those are categorical bars to saying you can't show good moral character if certain things exist, and one of them would be conviction of any of the crimes listed under 101F. And one of the ones is being pointed out is if you've served more than 180 days in incarceration, then you can't for whatever period you have to show good moral character, you can't show good moral character under 101F. But I think
He said that was his question.
that was the question. Okay, good. So we answered that question. That's a good question. I'll stretch my brain a little. That's good.
Is this the first slide?
Okay, yeah, I think that's it. Thank you. Okay, so this is kind of the analysis or the sort of template that I would use to analyze a criminal case for immigration consequences. And the first step is determining their immigration status. I don't know that I'm going to run through this in any great detail. I've just got a non-exclusive list of possible different types of immigration statuses. So the first one, obviously, is if you've got a U.S. citizen, and that seems obvious, but it's not that obvious. Brent Wolzen wrote a really nice article in the October 2010 issue of the Nebraska Lawyer about how different ways people can be U.S. citizens and not even know it. I mean, the obvious way is if they're born here, but there are other ways that people can be U.S. citizens, and there are instances, obviously, in which U.S. citizens have been deported from the United States and then found out later they were U.S. citizens. So it's not always as simple as you think, but certainly if you've got a U.S. citizen, then you don't have to worry about any of this stuff. They might be a permanent resident. They might be a non-immigrant, meaning they're here for a sort of limited period of time under special circumstances. They might be a refugee, someone who entered as a refugee. They might be an asylee, which is somebody who came here and then was granted asylum status. There are these miscellaneous categories out there: temporary protected status, NACARA recipient, Nicaraguan and Central American Relief Act, deferred action, a benefit applicant. I mean, there are all sorts of, and again, these are possible benefits that people either have or may have on the horizon, and you want to think about what the eligibility requirements of those are to see if this crime is going to kick them out of that category. They might be out of status. They may have initially entered but have fallen out of status. They might be undocumented. They might be a DACA recipient, which actually probably should go up in number 6 now. But there are all sorts of different kinds of immigration statuses, and it's important to know because you have to narrow your search as to what the immigration consequences are depending on what kind of non-citizen you have. So it's important to ferret that out, I think. But I would tell you that it's probably Strickland country not to even ask the question, are you a citizen or not? You've got to at least ask that question. So I'm going to skip through most of this. This is something that I do want to talk about in a minute, though. I think most immigration practitioners are aware of this, but and it's not really a Padilla issue, but it's something I want to put on people's radar screen. But this Adam Walsh Act really is kind of an immigration problem for a U.S. citizen in some ways, if you want to think about it. U.S. citizens have been convicted of what the Act calls a specified offense against a minor, can't petition to bring in a relative or fiance unless there's a finding that that U.S. citizen will pose no harm to the relative or fiance. So it's actually, if you've got a client who's a U.S. citizen and it happens to come up in the conversation, hey, I need to put this behind me because I've got my Russian bride coming to the country and we're going to be married in a couple of months, you might want to think about this stuff because it might inhibit their ability to bring their bride to the country to get married. And the specified offenses against a minor are all things that would probably set off alarm bells. It's just that this particular, and I'll call this a collateral consequence, is something that might not be on a citizen's radar screen, but any of these specified offenses against a minor fall under that act, and if your U.S. citizen client gets convicted of them, it's going to could certainly inhibit their ability to bring in a relative into the United States, a non-citizen relative. So that's something to be aware of in terms of immigration consequences, even for U.S. citizens. I'm going to run through, just sort of flip through these slides. And if you can alert me if anybody types in another question, I don't want to ignore the people that that are not here physically. But all of you are familiar with this stuff. This is what a green card looks like. They're actually green again, which is really nice. There may be non-immigrants. This is the bottom part of an I-94, which is anybody who's ever flown on an international flight. If you've made a mistake and said, I'm not a U.S. citizen, you get handed an I-94 instead of a customs form, and they've got information on them about the class in which the person was admitted, that sort of thing. This is a border crossing card that Mexican nationals, a lot of them would have. I'm going to skip through this stuff. And then the other kinds of immigration status, temporary protected status, and I've got up there that the removal analysis is different for these people because conviction of more than one misdemeanor will put their status at risk, unfortunately. Deferred action. Really, in terms of other kinds of immigration status, to the extent that they are able to get employment authorization, what you want to look at is their employment authorization document, and it will have a code on it that will tell you what their category of non-citizen status is. And all the categories for the employment authorization codes are in 8 CFR 274A.12C. And this is an example for those who have not seen one of an employment authorization document. And if you look at the category there, it says category C09. So what that tells me is that this is an adjustment of status applicant, and that's why he's eligible for this employment authorization document. But that category corresponds to the categories down there in the 8 CFR. So if you've got their employment authorization document, or can get it if they have one, that will help you determine what kind of non-citizen you're dealing with. Out of status, we talked about, those are people that have come in and fallen out. And then these are my clients. These are the good folks. These are my people. They just are here without documents. And so they want one of those work cards, and sometimes I can get them, and sometimes I can't. DACA, I'm not going to go through because I think people are pretty familiar with that. But again, it's a type of status that has different analysis involved. You don't want to screw up somebody's DACA eligibility if you can help it. And the criminal grounds of disqualification are you can't have been convicted of a felony, you can't have been convicted of a significant misdemeanor, and you can't have been convicted of 3 or more other misdemeanors. So again, these things standing by themselves for a sort of plain vanilla non-citizen like a permanent resident might not be a big deal, but if somebody's got temporary protected status or if somebody's got deferred action for childhood arrivals, then it's a different ballgame, which is why that first step of determining what kind of non-citizen you have is so important. And then, again, this is all, a lot of this information, almost all of this information is available on the USCIS website, which is actually a decent resource, except they really screwed up the page recently when they reorganized their website. But it's there, and you can find all of these definitions about what a significant misdemeanor is and what the eligibility criteria are for those programs. So the second step would be determining what am I worried about, inadmissibility or deportability or both. Just like this question that we just talked about, the first issue that I think about is, okay, well, what section of the code are we looking at? Are we looking at section 212, which is the inadmissibility section, or are we looking at section 237, which is the deportability section? And then determine the possible immigration consequences. So what I like about this is this step. So when I was a kid, I used to work on engines a little bit. I used to tinker, and I had these these blue books. I forget what they're called, but they were these manuals on working on cars. And if I wanted to work on the transmission, it said step 1, remove engine. Well, that's kind of what this is. It's like determine immigration consequences. It's a little more involved than that. But that's kind of what we've been talking about. But that's sort of the third step. Once you've identified them, Then you got to determine the immigration consequences. So let's look at some selected inadmissibility categories. And I want to talk about this one in particular because it's an interesting one. So crimes involving moral turpitude are a ground of inadmissibility. The problem is that crimes of moral turpitude aren't defined in the Act. We don't know what they are. That's left up to the courts to determine. That's the code section where you find that a provision saying that someone who is, and I'm going to say convicted of, a crime involving moral turpitude is inadmissible. In the cases, as close as they've been able to get is this kind of language. It's a crime that's inherently base, vile, or depraved, and contrary to accepted rules of morality and duties owed between persons or to society in general. Well, that's a helpful definition, but you know, you have to just apply it to facts. I mean, it's like any other generic definition. You just have to apply it to facts. So there are some major developments in this area, and they really go to categorical analysis, which gets us to DeCamp and other cases. And there's two really good videos. So just to set this up, the whole issue here when you're looking at crimes involving moral turpitude, and any crime for that matter, is if you're looking at a statute and there are some things that your guy or gal could be convicted of that might fall under parts of the statute but not under other parts of the statute, but they're convicted under this statute, have they been convicted of a crime involving moral turpitude? And it's a complicated analysis because statutes can be divided maybe into separate parts. Maybe they've got separate sections in them. Maybe they've got different ways of committing the same offense. And this whole area was kind of up in the air until 2013 when the U.S. Supreme Court decided a couple of really interesting cases. And the best explanation that I've seen of these are these YouTube videos. So I want to play them for you. They were done by a gal named Maureen Sweeney, University of Maryland Law School. And I think they're really good. So let's look at these. Hopefully this will work.
Categorical analysis of immigration consequences. Non-citizens can be deported or suffer other serious immigration consequences because of criminal convictions. These consequences often include deportation and can sometimes be surprising in their severity and disproportionality, and it's not always intuitively clear when they will be applied. To find out whether a conviction will trigger immigration consequences, you have to look to the Immigration and Nationality Act, the INA, the Federal Immigration Statute, and see whether the offense of conviction falls within any of the categories in the INA that trigger deportation or other consequences. The next question is how to determine whether an offense falls within one of these categories. To do this, courts use a categorical analysis. This means that the judge compares the elements of the state statute of conviction with the elements of the federal immigration category to see if the state elements are a match for, or if they are included within the elements of the federal category. In other words, does every violation of the state statute necessarily involve a violation of the federal offense or fall within the federal category? If so, the state statute is a categorical match for the federal category, and immigration consequences will be triggered by the state conviction. On the other hand, if the offense of conviction criminalizes a broader swath of conduct in the immigration category, then the offense is considered overbroad. An overbroad offense is categorically not a match for the federal offense and can't be used to impose immigration consequences. The categorical analysis does not consider the facts of what the individual actually did. The actual facts of the case are irrelevant to the analysis. The only question is whether the minimum conduct required to convict someone under a particular offense necessarily meets all the elements of the federal offense category. The Supreme Court recently reaffirmed the categorical approach in a case called DeCamp v. United States. Here's how the court used the analysis in that case. The first step was to define the elements of the federal offense that provided the standard for triggering federal consequences. A federal offense may be a statutory or a so-called generic offense, and you may find the elements in a federal statute, in case law, or even spelled out in pattern jury instructions. The key is to identify the elements that a jury must agree upon in order to convict someone of the offense. In the Descamps case, the Supreme Court was analyzing the federal generic offense of burglary. Federal case law defines the elements of generic burglary as an unlawful entry into a building or structure with the intent to commit a crime. In order for a state conviction to trigger federal consequences as a burglary offense, the state offense would have to meet all of these elements in every case. In Descamps, the Supreme Court compared a California burglary statute that had the elements of entry into certain specific locations with the intent to commit theft or a felony. The Supreme Court focused its analysis on the first required generic federal element, unlawful entry. There was no requirement under the California statute that the entry be unlawful. For example, the state statute covers an individual who lawfully enters a store but has the intention to shoplift there. The court found that the California statute prohibited all entries as long as there was a larcenous or felonious intent, regardless of whether the entries were lawful or not. As a result, the court concluded that the first state element swept more broadly than the corresponding federal element. In short, it was categorically overbroad, because the element of entry, which was not divisible, criminalized behavior that would not be prohibited under the federal definition. Because this element was overbroad, the court concluded that the California offense, even though it was called burglary, did not qualify as a federal burglary offense and did not trigger the additional federal consequences for a prior burglary conviction. The court made a point of emphasizing that it did not matter what Mr. Descamps had actually done in committing the crime. The question was a categorical one based on the elements of the state offense. In Justice Kagan's words, the key is elements, not facts. The court pointed out that this emphasis on elements is the same even for statutes that are divisible into alternative sets of elements that constitute different offenses, though courts can use a modified categorical approach to identify the relevant elements in those cases. But that is a topic for another time. The court's analysis in Descamps is a perfect example of the strict categorical analysis. If an indivisible element of a state offense of conviction is broader than its federal counterpart, a conviction for that offense will not trigger the imposition of additional federal consequences.
Okay, so that's Maureen Sweeney's explanation of the categorical approach to analyzing things, which I really like. I think it's a great approach. There's a follow-up one that I'm going to play too, where she talks about how you do it with divisible statutes, because I think that's a really good one also. But before we do that, I wanted to talk a little bit about the Mullooly case that came down just a week or two ago from the U.S. Supreme Court. Most of you probably know about that, but it was a present from the 8th Circuit to the United States Supreme Court. And I actually did we have a version of TED Talks at the Law College that we call STIR Talks, Share, Think, Inspire, and Relax. Thank you. And there's supposed to be 15-minute talks on topics. And so before Mullooly was decided, I did one called Is a Sock a Gateway Drug? Because those of you familiar with the facts of the case, they were so outrageous. So you had this guy, Mr. Mullooly, who was a non-citizen. I think he was a permanent. No, he was a non-citizen, but he was engaged to be married to a U.S. citizen. He got convicted of drug paraphernalia possession, and he got convicted under Kansas law. And what happened in the case was that he was pulled over for some traffic offense. I can't remember exactly what it was. He was booked into jail. When they booked him into jail, they found 4 Adderall pills that he had stuffed into his sock. And so they charged him with drug possession and a whole bunch of things, but one of the things they charged him with was possession of drug paraphernalia, which under Kansas law is defined as anything, any object in which you can store drugs. And so the drug paraphernalia that and so he took the deal. He pled to the drug paraphernalia charge. And the drug was not specified. So it just said drug paraphernalia, but it didn't say what drug was involved as part of the plea colloquy or anything like that. I think it was either a government oversight or a really sharp criminal defense lawyer that kept that information out of the record. But the drug paraphernalia was his sock. So he was convicted of possessing drug paraphernalia, his sock, and he was placed into removal proceedings because the ICE said, this is an offense related to a controlled substance. Offense related to a controlled substance. And it's pretty clear that drug paraphernalia offenses, I'm drifting away from crimes involving moral turpitude in case you hadn't noticed, but controlled substance offenses are deportable offenses, and drug paraphernalia offenses are crimes related to a controlled substance. So he was deported, and actually physically deported from the United States for possessing his sock. The argument in the Mullooly case was that this overbreadth argument. So the statute says you can be deported for a drug offense, but the drug has to relate to a controlled substance as defined under the Federal Controlled Substances Act. Right? It has to relate to one of those drugs. Kansas, and again, this is the sharp lawyering here. Kansas had, I believe, 9 substances on their schedules that were not on the federal schedules. And so the argument is, well, Kansas's statute swept more broadly than the federal one, because if you look at the federal schedules, they have 9 fewer drugs on their schedules than Kansas has on its schedules, and because the drug wasn't specified in any of the evidence that was in front of the court, we don't know which drug it was. It could have been one of the drugs that was not on the federal schedule, and those of you who are familiar with this area know that you have to prove that it's more than just some wild law professor type hypothetical, that somebody actually might be prosecuted for possessing some of these drugs that aren't on the federal schedules, and they were things like Jimson weed and things like that. And so the lawyers for Mr. Mullooly said, there's some evidence that Kansas actually prosecutes these offenses. So the record was really good. It goes up, and the Supreme Court said, didn't you understand what we said in DeCamp? In fact, this is exactly that kind of categorical overbreadth. We don't know. We can't divide it up. We're not going to look at the facts. We're going to look at the elements. We don't know what substances were involved. And so it could have been one of these other 9 substances. And so we can't say for certain that he was convicted of a crime related to a controlled substance on the federal schedules. We don't know that he was convicted of the federal generic offense. So Mr. Mullooly wins. And I think they're in the process of getting him back into the country at this point. So that was the most sort of recent example of how this categorical approach works. The argument in Mullooly that the government made was the language that says related to a controlled substance doesn't mean it has to be defined on the federal schedules. It can just sort of be loosely related to drugs. And the Supreme Court said, no, that's not right. Of course, except Justice Thomas and one other person who I can't remember right now. I think Alito and Thomas were the 2 dissenters. So even Scalia agrees, with this argument. Even Scalia agrees with this argument. Okay, so now I want to look at the other one that Maureen did on divisibility of criminal statutes, because it's sort of the follow-up to what you do if you've got a divisible statute as opposed to an indivisible one, like she just talked about.
Of criminal statutes and the modified categorical analysis of immigration consequences. When you want to determine the immigration consequences of an individual's conviction, you have to use what the Supreme Court has called a categorical analysis. This compares the elements of a state offense of conviction with the federal immigration category to see if the minimum conduct punished by the state necessarily constitutes a violation of the federal category. An earlier video explains the basics of that analysis. Here, we are looking at what happens when the state offense punishes conduct beyond the federal category. There are two possibilities, depending on the elements of your state offense. If the state offense is simply drawn more broadly than the federal category and is not divisible into separate alternative offenses, then it is categorically overbroad and cannot be used to trigger immigration consequences. This was the situation in the Supreme Court case of Descamps versus United States, which was illustrated in our earlier video. But if the state offense is actually legally divisible into two or more alternative offenses, the Supreme Court has said that it is then appropriate to apply a modified categorical analysis to see which of those alternatives was the offense of conviction and whether that offense is a match for the federal category. So how do we know whether a statute is divisible or simply overbroad? First, a court has to look to the law of the state to determine whether a statute includes alternative offenses with true alternative elements. If so, the second question is whether the alternative offenses as a group are divisible for purposes of the federal category. That is, whether at least one alternative fits within the federal category and at least one does not. We will focus on the first question, which is the more challenging one. This is because not every listing of alternatives within a statute or definition is a listing of true elements. Sometimes a statute may simply list different means of committing an offense that don't constitute true alternative elements. So how can you tell the difference between means and elements? Fortunately, the Supreme Court answered that question too in Descamps. For a variety of reasons explained in that case, including constitutional concerns, the court chose to rely on the indicator of jury unanimity to identify the essential elements of an offense. That is, if state law requires a jury to agree unanimously on which of the alternatives the defendant committed, those alternatives are elements of the offense. If the jury is not required to distinguish between the alternatives, then they are just different means of committing a single non-divisible offense. When looking for the essential elements of an offense, a court can look to a variety of sources, including the text of the state statute itself, state case law, jury instructions, and pattern charging language, as well as criminal treatises on state law or even law journal articles that discuss the offense. It's helpful to look at a specific example to see how this works. The Board of Immigration Appeals applied this divisibility analysis in a case called Matter of Chires. In Chires, the board asked whether a Utah firearms statute was an aggravated felony crime of violence, and the crucial question ended up being whether the Utah offense involved the deliberate intentional use of violent force. The board looked to Utah state sources to see how the state defined the required level of intent. It started with the text of the statute, which contained three provisions in separate paragraphs, A, B, and C. The board determined from the text of the statute that paragraphs B and C included a deliberate use of force, but paragraph A did not include an intent provision. Under Utah law, that meant an individual could be convicted of the offense for having fired a gun with either intent, knowledge, or recklessness. This collection of possible mental states defined conduct that would fall outside the federal requirement of deliberate intent, meaning that the minimum conduct prohibited by paragraph A did not necessarily involve a violation of the generic federal offense. But there was a further question. Could those alternative mental states mean that paragraph A was itself divisible into three separate sub-offenses? To answer this question, the board went back to the touchstone of jury unanimity from Descamps and asked whether Utah law requires a jury to agree unanimously on which of the three levels of intent a defendant had. Finding no such requirement, the board concluded that the alternative mental states were not elements of three different sub-offenses, but rather a listing of three different means of committing the single offense described in paragraph A. So paragraph A was not divisible, but simply overbroad, and a conviction for paragraph A could not be a crime of violence because its minimum prohibited conduct did not necessarily involve a deliberate use of force. This meant that the Utah statute was divisible with regard to the required level of intent, because B and C fell within the federal category and A did not. If an offense is divisible, A court may then employ a modified categorical approach to try and identify which of the alternative offenses was the offense of conviction. It does this by looking at a limited record of conviction, which may include charging documents, a plea colloquy or agreed statement of facts, sentencing documents, or a record of the verdict. The record of conviction does not include such things as police reports, pre-sentencing reports, or testimony in a later immigration proceeding. The record of conviction may contain enough information to identify the offense of conviction, in which case the court will be able to compare the elements of that alternative offense with the federal generic category to see if it is a match. But if the record of conviction is inconclusive and does not identify which of the alternatives was the offense of conviction, then there is no match, and the conviction cannot be used to support immigration consequences. In all cases, the comparison remains a categorical comparison of offense elements, and the facts of what the defendant may have actually done remain irrelevant, even if they are apparent in the record of conviction. What is relevant is the offense for which the defendant was convicted, not whatever facts about the circumstances may happen to have found their way into the record of conviction. In short, the modified categorical analysis is used solely to assist the court in identifying the offense of conviction from among possible alternative offenses included in a divisible statute. If the specific offense of conviction can be identified, its elements are then compared with the federal generic offense to see if the minimum conduct prescribed in the state offense fits within the federal category. If the offense is a match for the federal category, then immigration consequences can be imposed. But if it is not, or if the record of conviction does not definitively identify any of the possible alternatives as the offense of conviction, then there is no match with the federal category, and no immigration consequences can be imposed.
Okay, so that's the sort of follow-up analysis to the categorical approach, is the modified categorical approach. So some miscellaneous thoughts about this stuff. When I did this talk on Malooly and the categorical approach, and I played that first video for law students, I had some come up to me afterwards and say, this makes no sense to us. Why doesn't it matter what the guy did? I mean, if we're going to deport somebody, why shouldn't it matter what they did? And I guess the simplest answer that I can give is because that's not what Congress says we should be focusing on. Congress said we should be focusing on what they were convicted of, what crime they were convicted of. And the only reason that we even look in a limited way at what they actually did was to determine if there's a divisible statute, which of the different divisions they might have been convicted of. But once we figure out what crime they've been convicted of, that's where the inquiry ends. And there are good policy reasons behind that. The main one of which is we don't want to keep retrying these cases to find out what facts were involved. It's just too inefficient. By the time we get to immigration court, we don't want to retry the factual basis for this. We just are trying to figure out, okay, what crime was this person convicted of? And then once we know that, we can analyze the immigration consequences. So, you know, hopefully, but I understand, I mean, at a gut level, you say, well, it should matter what the person did, but it should only matter in the criminal case. It shouldn't matter once we get to the immigration context. So that's one thought. The other thought that I have is that, so now you see what DeCamp did to things. There was a BIA case out there that DeCamp just sort of smashed called Lanferman that said really the means are what we look at, not what the statutes are that they've been convicted of, not the elements, but the means. And so a lot of the analysis that I have in my now outdated guide at the end uses that sort of Lanferman analysis. It is, well, if there are different means of committing this particular crime, and one of the means of committing it might make this person deportable or inadmissible, well, then you have to worry about it. That's the part I need to update. So that's the caution I want to give those these days, is that it's probably way overly cautious because it used a Lanferman analysis rather than a DeCamp kind of analysis in terms of figuring out, whether there are immigration consequences. So you could make your clients overly paranoid, I guess, in some cases by saying, well, this could make you inadmissible or deportable because it may be under a DeCamp strict categorical analysis. They wouldn't be. So that's another caution I want to give on that. And then his way out the door, vacated a decision by Attorney General Mukasey, who rendered it on his way out the door, in this case called Silva Trevino, and that added another layer of complication to the analysis of whether we've got a crime involving moral turpitude. And what Silva Trevino held, I've got some slides on the side here. What Silva Trevino, that Mukasey decided held, was that there could be this third step in trying to determine whether or not what kind of crime this is, whether it's a crime involving moral turpitude. So the first thing is categorical approach, which we've looked at. Second thing is, if we're trying to figure out if it's a divisible statute, modified categorical approach, which section of the statute's involved. Third approach, which Silva Trevino added, was if those things don't shed any light on it, now look at the facts and see what the guy did, which is exactly what DeCamp has said you shouldn't be doing in cases. And so I think Holder, in light of the DeCamp case and other cases like that, said, yeah, I'm going to vacate this decision. I'm going to throw it back to the board, and they can develop the law. And in talking to people ahead of time now, that's kind of the hot issue right now is how are the immigration courts and the BIA going to think about the fact that Silva Trevino has been vacated, and we no longer can go to that third step in doing our analysis under the crime involving moral turpitude. And I would argue under all other ones, although I take it that's one of the issues too, is whether this vacature of Silva Trevino would apply to crimes other than crimes involving moral turpitude. But in any event, it's been vacated, so all the discussion in my guide or other things that you read about Silva Trevino and whether you got to worry about it, you don't. That case doesn't exist anymore. That Attorney General opinion doesn't exist anymore, and so we're plowing new ground here again in light of all these decisions. Yep.
From an academic standpoint, would you say that we're back to pre-Silva Trevino?
From an academic standpoint, and even from a practical standpoint, I'd say we're back to where we were before Silva Trevino existed. And I think all the advocates, except I think, and again, I'm the eternal optimist, but I really think we're in a better position because before Silva Trevino, we didn't have DeCamp, and we didn't have Moncrief, and we didn't have Malooly. We didn't have the Supreme Court repeatedly hammering the service saying, you're not thinking about this the right way, and you can't, the whole policy behind the categorical approach just doesn't work in that sort of a universe. So, yes, I think we're back there, and I think we're back there even in a better position than we were.
Categorical, modified categorical.
And
no outside the
categorical, modified categorical, end of discussion. That's where I think we're at. And I'm curious, those of you who have had to argue about this with immigration, if the thinking is otherwise on their part, what's the thought process? Or do you know how they're thinking about it right now?
It's kind of up in the air right now. But that's my argument that I've been making, is that we're right back to pre-Silva Trevino.
So your argument, and I'm repeating it not entirely because I'm done, but because I want other people to hear. So your argument is we're back to where we were before this even existed. And I think that makes sense. Although I remember going to a seminar, I don't know when it was, last fall or sometime, when Dan Kesselbrenner was out, and he and Matt Morrissey were on a panel. It was out at the zoo. Dan was talking about the Malooly case, which had then been argued, or hadn't been argued yet, but had been briefed and was waiting for argument in front of the Supreme Court. And I forget what the issue was, but Matt said, well, I can't remember what the issue was, but it was one that was clearly implicated by Mullooly, and Dan thought the decision of Mullooly was going to resolve that. And I think everybody else in the room thought that too, and Matt said, well, I don't know if it's going to resolve it or not. And Dan, being a nice guy, said, what's the argument? And Matt said, well, I just don't think, until the BIA comes down, I don't think we know. So it's like, I think we're back to where we were before this case was ever decided by Mukasey, but I don't know what ICE's position is going to be. I don't know how they're going to think about it. Yes.
DHS also likes to throw in copies of the police reports and the charging documents, and I think this gives you a stronger basis to have those struck.
Yeah, I don't think charging documents, charging documents maybe the information. If you get into the modified categorical approach, that is part of the so-called record of conviction. But police reports, PSIs, any of that stuff, clearly after decomp, no, you can't consider that stuff.
Then a judge will say, well, I'm not going to take it into consideration. So.
Yeah, I know. They know how to bulletproof their decisions.
Right.
Yes, they do that very well. But yeah, so I don't know. I just there's been a lot of really good developments in this area lately in terms of strict categorical approach. Yeah.
I just had a case the other day before Judge Fujimoto involving a modified categorical analysis of whether my client had committed an aggravated felony. And the whole issue in the case involved whether or not the judge could consider the record of conviction and comparing it to the federal statute. And Judge Fujimoto informed us that in light of the new case Malau, that he's finding my client is not removable.
Yeah. So this person had a case in front of Judge Fujimoto in immigration court, and it involved a divisibility analysis, and he's sort of saying now, in light of Mullooly, I have to really strictly follow this categorical approach and the modified categorical approach.
Right. He continued the case out to September just so that he could have a chance to write it all out.
So you got a favorable decision. You think you're going to get when he's indicated it, and he's writing the opinion now.
He indicated to the government and to us that this is the direction that he's going in, and that he continued it out just so that he could clearly, explain in writing the written decision why he's finding that the client is not.
Yeah. So Mullooly is having some immediate impacts here. I mean, again, I don't think Mullooly breaks any new ground, really. I mean, this shouldn't come as a surprise to anybody, including the government. The only sort of twist in Mullooly wasn't, we got decomp and we've got Moncrief, and they really say categorical approach, modified categorical approach into the inquiry. The only argument, and I read the transcript of the oral argument in Mullooly, the only argument the government had was this related to language. I mean, they really weren't even trying to argue that decomp and Moncrief were wrongly decided. They were just saying, well, this related to means you can look at related to in a sort of a general way, like, people are related, like I'm related to people in Russia because Adam and Eve were all our common ancestors, but that didn't fly either, so sounds to me like, after being beaten down 4 times on the Supreme Court, finally this is taking effect.
I think the government just doesn't want all these juicy facts to go to waste.
Well, they don't. I mean, they like to argue about the facts, but then they should be state prosecutors if they want to argue about facts.
Back to which statute or which subsection you're going to actually consider.
Yes.
I mean, and then that subsection is to be considered in a vacuum.
Yes, that's right. I mean, and that's what my students had a hard time understanding is, why doesn't it matter what the guy did? And I said it matters at the state level, but it doesn't matter here because all we're trying to figure out is what crime was he convicted of. That's all. That's all we're doing at this level.
State statutes tend to be very, very broad.
Yeah. That's an interesting point too. The point is that state statutes are very, very broad, so that what works really well for the government at the state level in saying we can prosecute all these kinds of things really can kind of come back on the overbreadth analysis at the immigration level to say, yeah, and because you prosecute all these kinds of things and they don't match up with the federal generic offense, they don't impose immigration consequences. Because the other thing that you have to do if you're arguing that the state statute is overbroad is to show that, in fact, there's a realistic probability that they could be prosecuted under the state offense, under this hypothetical that you're spinning out. And the way you prove that up is you go find some examples of actual cases where they were prosecuted for this kind of stuff. And if they're being prosecuted for things that would not be a match to the federal generic offense, then it's overbroad, and under DECON, no immigration consequences. So, yeah, I mean, what's good for the government at the state level is bad for them at the immigration level when you get there if you've got an overbreadth analysis, right? Okay, this is an interesting area. I'm just looking at our time here and trying to figure out how much more of this I can go through. You know, what I'd like to do, I think, right now is skip to my slides. I want to take a look at the post-conviction cases in Nebraska. So let me find those slides, and I just want to run through those cases because they're interesting cases, and they're, you know, they're relevant to criminal defense lawyers in Nebraska. So, let's talk about them. These cases are I think these are all up to date. They'll take us up through all the cases that I'm aware of that have been decided on a post-conviction side of things that involve immigration consequences. I divide them up into these different categories. The first one is failure of counsel to advise, so a sort of classic Padilla kind of situation. Second one is the statutory duty of courts to advise, 29-1819.02. And the third one is this thing I've already kind of hinted at about whether there's a constitutional duty imposed on the courts to advise. So if we look at, well, the first one starts with this Zarate case way back when, where our Supreme Court said no constitutional obligation to advise of what they called collateral consequences, which are immigration consequences. Well, that's gone as a result of Padilla. So then you take a look at this. I call this Gonzalez 1. It's a case that, this is one of Josh Ware's cases. And he gets the Supreme Court to recognize that there is a common law right to withdraw a plea in Nebraska under certain circumstances. And before then, our court really hadn't said that. Now, the court goes back and discovers this hidden treasure, so it's always been there. It's just that nobody ever knew that it was there. Justice Girard, before he went to the federal bench, wrote this opinion. So that's the main nugget of Gonzalez 1, is that there's this common law right to withdraw a plea. So you have these three ways of withdrawing the plea. You have a right to withdraw, attack it under the Post-Conviction Act if you're still in state custody, among other things. You have a right to vacate it if you weren't given the statutory advisement. We'll look at that line of cases. And then you have this common law right if neither of those other two avenues are available to you. And that's really what Gonzalez 1 establishes. The state went crazy on this, and they asked for a rehearing and got it. And so we have a Gonzalez 2 that we'll look at. But, I mean, they realized the ramifications of this holding. They were major. The other thing that I take from Gonzalez 1 that I don't think gets talked about as much is that really, so there's some question about whether you have to, how far you have to go in advising them of immigration consequences. And I said up front that I think you have to talk about whether or not it's going to imperil any possible relief they might be entitled to. And the reason that I think that our Supreme Court thinks that you have to talk about that is because in this case, Ms. Gonzalez was already in removal proceedings. Why? Because she was here without documents. What the claim was on ineffective assistance in this case was it's going to screw up her right to cancellation, non-LPR cancellation. And the Supreme Court went through this whole analysis about why this was deficient lawyering, right, under Padilla. And I don't think they would have done that if they'd have thought that it didn't matter whether she got advice about whether this plea deal was going to screw up her cancellation claim. So I think that's something that's in that decision, and I have stood up in front of various crowds, including judges, and I've said that, and nobody, I don't see a Supreme Court decision yet that says you're wrong, although I'm sure it's coming. but you know, right now, that's, I think, what Gonzalez stands for, is that you've got to go that far when you're advising people. She was convicted of welfare fraud, generically speaking, as I recall. So receiving public, the criminal defense lawyers here will know the statute, but that's what she was convicted of.
So CIMT.
Yeah, a crime involving moral turpitude. Right, that's what it was.
Which would allow her cancellation application to be pre-remitted because of good moral character.
That's right, because she couldn't, it would have screwed up her cancellation claim. That's exactly right. So what happened in Gonzalez 1 was that they didn't give her the relief because they held, excuse me, that she didn't demonstrate prejudice under Strickland's second prong, because her testimony at the post-conviction hearing was, if I had known about the immigration consequences, I would have looked for another solution. And our Supreme Court said, well, that doesn't go far enough. That doesn't say, because the prejudice prong requires you to prove that you would not have taken the deal, that you would have insisted on going to trial, and that decision would have been objectively a reasonable one under the circumstances. Which is why those of you who are involved in post-conviction work in this area need to read that remand case of Padilla to the Kentucky Court of Appeals, because it says what would motivate people to go to trial who don't face immigration consequences, and what would motivate people to go to trial who do face immigration consequences, you can't even think about the same way. And so while it may not be objectively reasonable for a citizen to say, I would have gone to trial, may be inherently reasonable for a non-citizen facing immigration consequences to say, I would have not gone to trial. And there's some really good language in that Padilla case on remand that helps that argument along, I think. So anyway, she lost on her post-conviction claim because she couldn't prove up on the prejudice prong. So then you've got the rehearing, because the state says you can't mean that there's a common law right out there. And in Gonzalez 2, the Supreme Court said, yeah, we do mean that. We mean that there's a right out there. And oh, by the way, since we decided Gonzalez 1, because her plea came before March of 2010, we've now got this Chaidez decision from the U.S. Supreme Court that says Padilla is not retroactive, and so she loses again, because even if she could have proved up on prejudice, Padilla doesn't apply retroactively, so she loses. But there's this common law procedure out there, and we're going to reaffirm that. And then they go into great detail. I mean, they do a nice job sort of laying all this stuff out, but here are the 3 procedural mechanisms. The last mechanism is only available if one of the first 2 is not. And that was the other issue in Gonzalez 2. The state kept tinkering around with, well, this isn't available if the conviction is final. Even if that right exists, or that remedy exists, it doesn't exist once the conviction is final. The Supreme Court said, well, yes, it does. We don't see any reason why the rule would be different for non-final convictions as opposed to final convictions. And so that's the other thing that you take away from Gonzalez 2, is that there's a common law right, and it exists even after the conviction is final. It's available only for constitutional violations, but that's what Strickland is. It's a constitutional violation. And then they talk about why those other 2 remedies weren't available to her. Oh, okay, so it wasn't, okay, I'm sorry, I got that wrong. So it wasn't that although she did testify, I would have looked for another solution. They said that she could have proceeded under the Post-Conviction Act because she was in state custody during the time of her probation. That counts as state custody, or at least she didn't prove that she was in federal custody, so that's why the common law remedy wasn't available to her, because she could have gone under the Post-Conviction Act. So that's another lesson from Gonzalez too, is that probation equals state custody for purposes of which remedy you have to use. But this is the great language from that case. The right Gonzalez and similarly situated defendants seek to vindicate is a right to the effective assistance of counsel, which is a right granted by the Sixth Amendment. When such a right is at issue, and there is no other means of vindicating it, we refuse to deny a defendant due process of law. The cool thing about that statement, other than just, the statement itself, is that the first opinion was written by, Gonzalez 1 was written by Justice Girard. Then he leaves the court, and on Gonzalez 2, he's no longer there. This is a per curiam opinion, so everybody signs off on this opinion, which is really cool. The whole court says, this is what we think about this claim. So it's pretty strong language. Then you've got the State versus Diaz case, which Mark Porto out in Grand Island brought up, and he tried, Josh Ware and he were really talking to each other a lot during this time, and he said, well, I want to try this writ of error coram nobis, because I've heard about this thing, and I've seen it work in federal cases as a remedy to get a vacatur where there was no immigration advice provided by defense counsel. And our state Supreme Court said, yeah, that really doesn't work in Nebraska because it relates to facts that the defendant didn't have knowledge of at the time, material facts. And what Padilla is a change in law, not a failure of facts. And so even though it works at the federal level, it's because at the federal level they define the elements of this writ differently than we have historically in Nebraska. So the bottom line of State versus Diaz is this writ of error coram nobis doesn't work in Nebraska, where the claim is the law changed, not there were some facts out there that I wasn't aware of. I don't know, because I see what you're thinking. You're going to ask me about why that wouldn't work in Mammer, and I haven't thought about that.
I used to do the coram nobis before this case.
You did coram nobis before this case, and then Mark ruined it for you. Yeah.
So then you just do motion.
So I think you either do after this case, you've either got to do one of the other three. I think you got the common law writ, or the Post Conviction Act, or the statutory ground. Yep. Then you've got State versus Yuma, which again is Josh Ware back at it again, and he says, okay, so we've gone so far as to say in Gonzalez 2, it's available after the conviction is final. Now State versus Yuma holds, and that common law remedy is available even once you've been released from sentence. So it's available to vacate that plea if there was ineffective assistance, no matter at what stage, even after the completion of sentence, because it's a constitutional defect and we need to have a way to remedy that. The beauty of that one is if you can avail yourself of that, and it's available after the sentence has been convicted, and suddenly the state doesn't have any evidence to prove up on a retrial, then your guy avoids the consequences altogether. The State versus Osorio talks about, okay, so there's been a lot of litigation in state courts about whether or not the Teague versus Lane analysis, which is retroactivity of decisions like Padilla, whether that applies. Now, the U.S. Supreme Court in China says as a matter of federal law, Padilla is not retroactive. But there are a lot of organizations out there that were doing some analysis about whether that would be true at the state level, because the state analysis is different, could be at least different from the federal analysis. It doesn't have to track the federal analysis. Our Supreme Court, again, I don't think it ever actually, and I'm still not sure they've actually been really tested on it, but in this case they say pretty clearly that Padilla is not retroactive. I don't know that, I think they're just saying because of Chaidez, because of Chaidez, because of Chaidez. There are some Supreme Court cases out there from other states. Massachusetts, it's one. New Mexico is one, in which they say under a state analysis, we think it is retroactively applicable. So if you're really desperate and you've got the time to litigate that issue at the state level in Nebraska, I'm still not sure anybody has really made our Supreme Court think hard about that under a state analysis. And if you want some guidance about how the state analysis might differ from the federal analysis on retroactivity under Teague and under Hill versus Lockhart, look at that Massachusetts case, look at some of those other state cases out there in which the Supreme Courts of those states have held that it's retroactive under a state analysis. It might be. Manor, I've already beat that horse. Okay. So that's sort of the Padilla side of the post-conviction cases in Nebraska. Now there's a whole string of cases, and actually this is the majority of the cases that talk about what about the statutory duty to advise, and under what circumstances might that give rise to what I'll call a post-conviction claim. And again, this statute became effective July 20th of 2002, and it provides, in essence, that if a court doesn't give the advisement and that failure is coupled with a showing by the defendant that there may be removal consequences, then the defendant can vacate a guilty plea as a matter of right. So let's look at those cases. So the first one that came down is this Rodriguez-Torres case. This one is a problem case for the Supreme Court. It turned out to be a problem case. But what it held is that you can't use the statute to vacate a plea entered before the effective date of the statute if the defendant has already completed his sentence. It goes on. What created a problem for the court in this case was that I think the court just got a little slap happy when it was making this decision, and they implied that it wouldn't be available to anybody whose sentence is already final even. So it goes well beyond, I think, where the court thought it should have gone, and the court had to do some backtracking later on. McCormick writes this opinion. But the essence of it is the defendant can't use the statute to vacate a guilty plea that was entered before the effective date of the statute. Then you've got the State versus Rodriguez decision from 2014 that says he can use the statute to vacate pleas. Oh, geez. Why did I say pleas like that? It should not have the E on the end of pleas. Well, maybe that was a Freudian slip. Pleas entered after the effective date of the act, even if he's already completed his sentence. The reason you have State versus Rodriguez on the heels of State versus Rodriguez-Torres, not on the heels, but afterwards, is because they have this broad language in State versus Rodriguez-Torres that says, well, it's just not available, there's no remedy available if he's already completed his sentence, or even if his conviction is already final, which suggests that the only way to raise this is on direct appeal, right? And the court in some intervening decision said, no, that's not right. It's a motion to vacate. You don't raise it on direct appeal. So Stephan writes the opinion in State versus Rodriguez, and he goes to great lengths. It's fun to watch the contortions that he goes to do away with this broad language in State versus Rodriguez-Torres. And he kind of, it's an admirable job. I mean, Fred Astaire would have been proud of the way he danced in this case, but he sort of says, well, you know, we're not sure that, first of all, he says, well, this is kind of dictum in State versus Rodriguez-Torres when we said this. We really wasn't necessary to us deciding the issue in the case because, in fact, you know, he hadn't already completed his sentence. Anyway, and then he goes on and he says, there are some other differences. And then at some point in this Rodriguez decision in 2014, he says, so we realized that maybe some people would get the idea that we think that it's not available even after he's completed his sentence. We're not sure where they get that idea. And I read this decision in 2014, and I think they got that idea from reading Rodriguez-Torres. That's where they got the idea. But he says, to the extent that there's this misapprehension out there, we expressly disapprove of that notion. So he does a pretty good job of bailing his buddy, Justice McCormick, out on this, I think. But the bottom line is that whatever broad language you see in Rodriguez-Torres about at what stage of the proceedings this vacature right is available, it's available at all stages, even after completion of sentence. That's the bottom line. But they had to go through some contortions to get there. Then you've got this guy, Mr. How do you pronounce that, Spanish speakers? Yoshigil, something like that. Anyway, Mr. YC, he's litigating this stuff pro se. He doesn't even have a lawyer. He's making law in this state pro se. What happens is that he gets the statutory advisement given to him, but it doesn't anywhere resemble the language in the statute. It's just sort of, hey, there could be some immigration problems out there for you, the court says to him, rather than reading the statute itself. I'm paraphrasing, but if you look at the language of the advisement given to him and you look at the language of the statute, they don't really line up very well. So he says, well, that's wrong. I want to vacate my guilty plea. And so he starts this post-conviction claim, and they say, well, okay, you can use the statute to vacate a guilty plea even if your judgment is final, as long as you haven't completed your sentence. So this is before the 2014 decision in Rodriguez that says, even after completion of sentences, okay, this is sort of the intermediate step. So we know that you can do it. Before the judgment's final. Now this says you can do it even if the judgment is final, and then Rodriguez says, and even after completion of sentence. So we've gone the whole way there. But remember, Mr. YC, that there's this other part to the statute, and it says not only that you have to show that the advisement wasn't given, but you have to show that the conviction may have immigration consequences, and in this case, you didn't put any evidence on that prong, so you can't win. So, sorry about that.
Question.
Yes.
So, in Rodriguez, it says the defendant can't use the statute to vacate the pleas entered after July 2002, even if he has already concluded.
Entered before. Rodriguez-Torres says he can't vacate it if the plea was entered before the effective date of the statute. Right?
No, the statute itself gives the court discretion to vacate before July 2002.
Yeah, but it's not a matter of right. Not a matter of right. That's the distinction.
But you can still make.
You can make the argument.
Discretion.
And now tie it into that. And I can't remember which case it is, but now tie it into that Fifth Amendment-ish argument that this is why you ought to exercise your discretion. Make the court feel guilty. That's easy to do, isn't it? Make judges feel guilty about stuff. I've never had much luck doing it that way. But yeah, I think the statute says you have the discretion to do it. It's just that you don't have a right to do it under the statute. Now you got State versus Mena-Rivera. Here's Josh Ware back at it again. The funny thing about this case, which I learned later, because this was up in Saunders County, and Judge Gilbride is just mad as a wet hen about this case, and the reason is because Josh's client ended up being a U.S. citizen, as it turns out. Nobody knew it at the time, so we've got all this litigation about immigration consequences, and the guy was actually a U.S. citizen. It's really funny, and Judge Gilbride is still angry about that, that she had to get called out by the Supreme Court on a case where it didn't even really matter. But anyway, what happened in this case was that you've got this sort of procedure that sort of gets strung out in terms of this guy appearing in front of the court, and he wasn't given an advisement at the time that the guilty plea was accepted. He was given that advisement earlier, and I'm not remembering the exact time frame, but I'm thinking it was like a couple months ahead of time. And the Supreme Court says, and I think Justice Connolly wrote this opinion, the Supreme Court says, we think, when it says prior to in the statute, we think it means immediately prior to. And 2 months out is too long, because he can't understand, he probably won't retain this information when it comes time to actually take the plea. So you got to give it to him immediately before the guilty plea is accepted. And the other thing that Mena-Rivera teaches us is that Josh's proof on the second element, which is possible immigration harm, is there's an ICE detainer. And the court said that's enough. That's enough to show possible harm resulting from this. So you've met both elements, 1 and 2. It wasn't given because it wasn't given immediately before the guilty plea was taken. And you showed possible immigration harm because there was the existence of a detainer. And so you get a vacate. and Judge Gilbride is still hot about that case. Now comes Mr. YC again, and he says, I want another crack at this. I'm still pro se. I want another crack at this. And I really fastened on this argument, guys, that he didn't give the statutory advisement. His language didn't track the statute. And the Supreme Court said, you know, it's an interesting issue, but we don't have to decide it because the decision, there were two decisions in this case. The one that got made on that was a decision in a special proceeding, which became a final order immediately, and you didn't appeal it within 30 days. So we don't have any jurisdiction to hear that argument that the advisement didn't exactly comply with statutory language. And they also say, and oh, by the way, in case you're wondering, and this is in dictum too, that there's no constitutional obligation on the court side to advise of possible immigration consequences. The problem that I have with that decision, one, is that it's dictum, and two, if you look at the authority that they cite for that proposition, it's a Georgia Supreme Court case, and if you read the Georgia Supreme Court case, it is a post-Padilla case in which somebody makes the argument that there's a Fifth Amendment obligation on behalf of the courts. And the court says the reason, the Georgia Supreme Court says the reason there's no Fifth Amendment obligation is because immigration consequences are collateral consequences. And you're going, what? What? You didn't read Padilla? It says they're not collateral consequences. So it's a pretty slim read that legal proposition rests on, in my opinion. I think that one is ripe for plucking at some point if you're interested in pursuing that argument. State versus Medina Liborio. I think this came through the Court of Appeals. I think there was a Court of Appeals decision on it first before it landed in the Supreme Court. And the propositions here are that you have to file the motion to withdraw a plea. That's the proper procedural vehicle. You don't do it on direct appeal. You don't raise it as an error on direct appeal. The other thing about this is, so in this case, the state wants to put on evidence that says, hey, when this guy visited with his family, we're listening in because it was done in the jail. And what he's talking with them about is, geez, I'm worried about the immigration consequences here. What do you think? And there's this long discussion that the state gets into the record about this guy knew about the immigration consequences, and the fact that the court didn't advise him of it doesn't matter because now, to turn Mamre on its head, the fact that he knew about it from collateral sources cures the failure of the court to advise under the statute. And what the Supreme Court says is, no, that doesn't matter. This is a statutorily imposed duty on the court, and it doesn't matter. It's sort of like the categorical approach, right? We don't care what really happened. We only care whether the statutory advisement was given because the legislature has obviously made a decision that this is something that judges have got to do. It wasn't done in this case, and so all of this out there, all this evidence out there doesn't matter. Heavican dissents. He doesn't like this decision and says, gee, that's not right. I would have allowed that evidence in. I would have held that it matters. Castle writes an interesting concurrence in which he said, you know, if we hadn't decided all these other cases saying that this is statutory right, I would be persuaded by the dissent. But I kind of feel myself bound by our prior precedent. So that's Medina Liborio, and it's a real interesting factual case. So then you've got this case, this Arenas Alvarado case, and this is a Court of Appeals case, all right? Now remember the Medina Liborio case, the one that Judge Gilbride is so angry about, and it says the advisement has to be given immediately before the plea is taken, and 2 months out is too far. So there's this multi-phase advisement, 6 weeks apart, and the defendant, actually I want to get this case because I want to compare it to the Medina Liborio case. So he appears in the county court on June 7th of 2011, and with the assistance of a court interpreter, he gets advised of his rights, okay? And then on July 14th, so a little over a month later, he appears before the district court for a group arraignment. The district court advises the group of their rights, including the right to counsel, blah, 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 blah. And it also gave the advisement, the statutory immigration advisement under 1819.02. Okay, so that's on July 14th. Then on August 29th, the parties appear for a pretrial conference pursuant to a plea agreement. The state requests and is granted leave to file an amended information, but he wasn't ready to enter a plea at that time, so the state withdrew the amended information and it got continued to September 1st. September 1st, they're in court again, and they indicate a plea agreement has been reached, and here's the colloquy, the court. And sir, when we were in court on July 14th, right, this is September 1st, when we were in court on July 14th, I explained to you your statutory and constitutional rights. Do you recall that? The defendant, yes. The court, do you want me to repeat any of that information for you? What's the answer, criminal defense lawyers? Yes, repeat it, or maybe not, depending on what you're trying to accomplish. Well, the defendant says, no, that's not necessary. Court, I also on that date advised you of the possibility of deportation from the United States. Do you remember that? Defendant, yes. Court, do you need time for me to repeat that advisement? Defendant, no, it's not necessary. Okay? So then he wants to withdraw his plea, and his argument is it wasn't given immediately before. And when you read Medina Labordia, you think the guy's got an argument here, right? Now, it was 2 months in that case. It's a month here. What does the Court of Appeals hold? The Court of Appeals holds that's okay. He didn't make a possible showing of possible removal consequences. He would have failed under the second prong in any event, but they kick him out on the first prong. And they say, and I want to read the court's decision to you, or at least part of the rationale anyway. They basically say that the purpose of the statute was the intent of the legislature was satisfied. Close enough for government work, basically, is what the Court of Appeal holds. Well, if you read Mena Rivera, and you read this case, I don't know about that. It didn't go up to the Supreme Court for whatever reason. So this is the final word on it in this case. But I really wonder, they're pretty, if you read that Mena Rivera case, I think I've been saying Medina Labordia, if you read that Mena Rivera case, that language is pretty strong in that case about immediately prior means immediately prior, and I think a month is not immediately prior. And I think the Court of Appeals, again, did a nice tap dance to get out of it. But here's the language that I want to read to you, because I'm back on this Fifth Amendment argument. So one of the issues is here whether the plea was voluntarily and intelligently made. And they talk about a state Supreme Court case, State versus Lee. Nebraska Supreme Court set forth the requirements for determining whether a plea has been voluntarily and intelligently made. And the court has to inform the defendant concerning the nature of the charge, blah, 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 blah. And has to inform the defendant, or has to be satisfied that the defendant knew the range of penalties for the crime for which he or she is charged. Now again, go back to that language in Padilla that we looked at where the Supreme Court said immigration consequences are part of the penalty imposed on non-citizen defendants, and yes, we know they're not criminal penalties, but they're penalties nevertheless. That language right there from that State versus Lee case, I think, is the hook to raise this Fifth Amendment argument if you're inclined to do so in a post-conviction context. But then the court goes on and they say, an evaluation of the facts reveals the legislative intent of the statute is not frustrated in this case. The defendant was reminded of the advisement and acknowledged that he understood its meaning. He was specifically reminded that the immigration advisement applied, though the charge had been amended from the time of the initial arrangement. Further, though he was not reminded of the advisement on the day that he entered his plea of no contest, he was specifically reminded of the advisement on the previous day as part of the same proceeding, and the charge had not changed from September 1st to September 2nd. So they're narrowing it down to a day's time. Even though it was a referent, it wasn't, I don't think it was read again, he was just reminded of it specifically. I read the language. I wrote in the margin here, that's a pretty thin read for distinguishing this case from Mena Rivera, in my opinion. pretty thin reed, but it worked. And he didn't get it worked for the government, and he didn't get to withdraw his plea. But that's an interesting opinion, too. So this is, Judge Castle in Medina Laborio writes this concurrence. No, this isn't the concurrence. This is the language. Statute makes the trial judge responsible for giving the advisement. The prosecutor, so again, so say that language from Padilla, everybody's involved here. The prosecutor, in the interest of securing a valid plea-based conviction, also has a role in making sure that the advisement is given. This is Justice Steffen's language. Because the argument of the government was this guy's trying to game the system. And Justice Steffen says you can game the system only if both the court and the prosecutor don't do their job. Otherwise, there's no game to play, basically. And so that language from Medina Laborio says, you know, we're not going to countenance these arguments that this is some sort of gaming of the system somehow. If you do your job, judge, and if you do your job, prosecutor, then there's no way that the system can be gamed at all. Then in this Rodriguez case from 2014, this is Justice Castle's concurrence. There is no excuse for failing to administer the statutory advisement. It takes only a moment. The wording is succinct. The statute specifies the precise language. Judges have no reason to improvise or summarize. The cost of timely giving advisements is minuscule compared to the benefit of avoiding plea withdrawals years after the resulting judgments have been fully executed. Judges should fully and timely comply with the statutory mandate, and the practicing bar should ensure that judges do so. There you go. Justice Castle is fed up with this stuff, and he says, if everybody would do their frigging work, we wouldn't be hearing these cases. And he makes a good point. I would also go on to say, and I think Bill would say this too, I can call him Bill because he was a classmate of mine. I think he would say, and you know, it also effectuates the purpose of Padilla. It also effectuates the purpose of the Sixth Amendment, to have competent counsel. So, you know, there's lots of good reasons why you ought to do this stuff. Do it. So this is the Fifth Amendment argument. I've talked about that already. There are these lingering issues out there about, do courts have a constitutional duty to advise? And if so, how is that duty carried out? What role should potential immigration consequences play at the time of sentencing? I think they play a huge role, and I think that that argument ought to be made at the time of sentencing. And what's the prosecutor's ethical responsibilities to take immigration consequences into consideration? Now let me poll people. What attitudes do you face, either here in Douglas County or elsewhere, on prosecutors if you bring this stuff up to them? When you're negotiating a deal and you say, you know, there are these immigration consequences that we could avoid if we have this deal rather than that one, what attitudes do you encounter?
Depends on the county.
Depends on the county?
Yeah.
So,
but generally, they're pretty understanding and we'll try to work a deal with them. And they will know that we practice immigration law as well as criminal law.
what? I'm sorry, what was that? In Scottsbluff County? How do I get that back? They don't care at all. Okay. Well, that's too bad. So what I'm hearing here is, and thank you for that input from Scottsbluff County. What I'm hearing here is that it depends on the prosecutor, but that generally most of the ones you've encountered are at least willing to listen to that. I think if you go back to this language and you go back to the language in Padilla, there's room for educating prosecutors who either say, I don't give a damn, or, oh, great, I can get punishment and get the guy kicked out of the country, so much the better, right?
Well, and here's the other thing, too. It's not just them understanding, but it's often when you're representing someone that's got, you know, deportation hanging over them, you are more inclined to go to trial.
Yes.
And so there's an incentive for the prosecutor to
Yes.
actually,
Yes.
you know, make it
So
so
the
that
point
it
here,
benefits the defendant.
yeah, the point being made is if you're representing somebody who's got potential immigration consequences, it's more likely you're going to try the case rather than pleaded out, and so it is in the prosecutor's interest to work a deal that would avoid the trial. Absolutely. Which is exactly what Stevens said in Padilla, and exactly, I think, what Castle is getting at here. So, again, I understand this is an educational process. You're not going to change anybody's mind who's thinking about it otherwise, but you use language like this to try to get them to think about it in a different way. It really is in their own interest. There's frequently, not always, of course, I understand, but frequently the way to satisfy the state's interest in punishment and your client's interest in avoiding removal. And if you can do that, then I think the prosecutor ought to play ball. And I think, I mean, Bill says, you know, practicing bar ought to ensure that judges are doing their job too. So, you know, again, I'm going back to what Ross is going to try. I don't know what's going to happen up in Cumming County next week, but you know, he's having a go at it because he believes this stuff. He believes what he's reading in Padilla. He believes what he's reading here. And he's trying to get prosecutors to believe it as well.
Did you say Ross is making the Fifth Amendment argument?
It's just a sentencing argument that he's making. He's saying, if you put my guy in jail for 3 days, he's going to get picked up. And if you don't put him in jail, he won't.
Put him in jail for 1 day.
They put him in jail at all. He's saying no jail time. And I know that the prosecutor has this policy of imposing jail time on a subsequent operating without a license, but there ought to be a difference because of the immigration consequences involved.
The argument that you were making earlier about the Fifth Amendment was that since you read Padilla, that deportation is not collateral, it's a penalty. Basically.
Right, it's a penalty.
It's a severe penalty, actually.
Yes.
And so a judge who, before he takes a plea, can only really accept a plea when it's knowingly, intelligently, and voluntarily made, should treat deportation or the consequences like reading out, okay,
yes.
You're pleading to a Class 1
yes.
misdemeanor or
yes.
a Class 4 felony.
Yes. That's my argument.
That's your argument.
My argument is, and again, I know it's not the same because it's not a criminal penalty, but you've got that language that says it's also not a collateral consequence in Padilla. And so my argument is it's closer to the penalty, because I'm fastening on that word that Stevens uses. It's closer to a criminal penalty than it is to a collateral consequence. And I think that if the Fifth Amendment doesn't sweep it in, at least best practices in this kind of stuff ought to make judges think about it and ought to make them tread more carefully when it comes to this. Because they're not supposed to accept the plea. And they can't say, what have you been told? But they can say, have you talked about this stuff? And be very specific about that question. Yeah.
Missed a comment again.
Oh, another comment? How do I get back to those? I don't want to miss the comment.
Comment or question.
How do I?
It's going to be the go to meeting.
Oh, this is here. Okay.
Yeah, I'm telling her.
Nope,
No.
not that. Sorry. Oh, this. Okay, good. Okay. Except for 2 of the 6 prosecutors, I get no sympathy on this issue. We want to try all these cases, and I personally tell prosecutors this. Yes. And they usually come down especially, and I know that domestic violence cases are, hot. I mean, that and drunk driving seems to be the sexy crimes right now as far as immigration is concerned. They're all over those cases. And again, I'm not in favor of either of them. Don't misunderstand me. I question whether or not the state's punitive, exactly. I really appreciate your interaction from Scotch Bluff. I really like it. I just think this. I got to meet this guy. I think that the judges and prosecutors need to be pulled into this discussion. Yeah.
What would you say about prosecutors that actively want your client to be deported? I mean, you tell them my client's going to be deported. Okay, well, let's go forward with trial, or let's go forward with a plea where your client will be deported.
Yeah. So
I've had prosecutors tell me things like that they make sure they call ICE after the case to make sure the client has been deported.
Yeah.
Or, things like that. I mean, is there any remedy to that, or?
So the question is, what do I think about prosecutors who actively try to layer the immigration consequences onto the criminal case. And what I think is that, and I don't have the ethics rule in front of me, but you all know what it is, and it says the state is supposed to seek justice, not to just convict. And I think that if it got egregious enough, I would tattle on them. That's what I think, because they're not seeking justice. If you've got a viable alternative, I mean, if they can argue to you, my punitive interests, the state's punitive interests aren't served by your suggested plea, okay. You know, I may disagree with that argument, but at least it's a valid and an ethical argument. If they're saying, I can achieve the state's punitive objectives, and I'm going to affirmatively go out there and try to impose some non-criminal, you know, civil immigration consequences, I think they've overstepped. That's what I think. And I'd tell them that if they were standing here. I don't think that's an appropriate thing for them to do. Yeah.
Piggybacking on what Chris said, sometimes the fact that you tell them, listen, my guy has status issues, and this is going to have immigration consequences, leads to a retort, well, you know, why should he be or she be treated any different than a citizen?
Yes.
In fact, it's worse.
Yes.
Because
Yes.
they don't have status.
Yeah, so the argument that
And
some...
of course you wrote in it, right?
Yes. The argument that is sometimes raised is, well, why should I treat a non-citizen differently than I would treat a citizen? And that's exactly the argument that Ross is facing up in Cumming County. This is our policy for everybody. And his argument is, you're not treating them the same. You are not treating them the same. Because these people, and look at Padilla, there's something different about immigration consequences. And in fact, you're treating them worse because you know that you are imposing an additional burden on them, and that's not treating them the same. You can't stop at the criminal analysis.
I think the underlying basis for the county attorney's policy there should be to protect the public against bad drivers. You know, I mean, the whole point of requesting jail is to keep somebody from getting behind the wheel because they're dangerous. They demonstrated an inability or an unwillingness to follow the rules of the road, or they have too many DUIs. They're a danger to the public. And so in order to discourage them from getting behind the wheel, we're going to, institute a policy of requesting jail time. But that underlying basis doesn't really apply in the immigration context because their status has nothing to do with their competency to drive safely.
Right, that's exactly right. I mean,
they'll argue that they have an inability to get a license, and therefore they're not driving legally.
Yes, that's correct. That's correct. And so there are the prosecutor's argument is, well, they can't get a license anyway, and so even if I don't impose jail time, they're going to go out and drive again. And now you get into the policy level, but again, it strikes me. I don't understand much about criminal law, but my limited understanding is that a lot of stuff is fair game at the sentencing phase, right? I mean, just listen to this Boston bomber testimony stuff at the sentencing phase. Almost anything is available, so you can get into policy arguments. And where Ross is headed with this stuff is, okay, you want to say they can't get a driver's license? Let's see why they can't get a driver's license. What's the state of Nebraska's position on DACA recipients getting driver's licenses? What's their position on administrative action? Are they one of the 26 plaintiffs in this lawsuit in Texas? Is the state actively preventing them from getting driver's licenses? And oh, by the way, have you eaten fruit lately? Have you eaten vegetables lately? I mean, he's going to get into this stuff if the judge will let him. And I think it's fair game, but it's all about advocacy because we understand immigration consequences of criminal proceedings. And that's what Padilla requires us to do. So that sounds like a good sermon to end on. So let's end. Oh, well, let me